May I permit to mention, my lord, for inclusion in the list, my lord, matter is most urgent, my lord.
Under what heading?
New motion,
New motion, please hand over the slip.
my lord.
May I to mention, my lord, for application, heading application, matter has been dismissed for default, my lord.
Application hand over.
May I permit to mention, my lord, for upgradation?
Application, please wait. Many slips have been taken. Please wait for some time. Yes. Call the list.
I appear, it has come at my instance, my lord.
Yes.
There was a direction for affidavit, my lord. The respondent failed to, my lord, respond to the affidavit.
They will not be allowed to file affidavit.
No, my lord.
I am.
The affidavit is ready.
Because we are out of time, Milord, kindly.
Mr. Bose is opposing his.
He is ready to oppose. He has the right to oppose.
But my lord, I on the day, my lord, when it was taken up, my lord, last day, I requested and persuaded your lordship, my lord, at least that is my perception, that is a dismissed employee. I, my lord, pray with humility, my lord. I shall file affidavit. I shall.
Proceeding.
Yes.
Assigned matter.
No, it was cooperative.
Oh, cooperative.
So, my lord, I request your lordship, my lord, from your lordship's busy schedule. I know, my lord, your lordship is facing insurmountable difficulties. Even then, kindly give your date.
Mr. Bose,
No, my lord. No, my lord.
hearing matter.
No, my lord. I tell you, lordship, this is not a run-of-the-mill case, my lord. Kindly see, my lord, I am out of my job. Here, my lord.
Mr. Bose, firstly, in this type of matter, scope is very limited for interference and gratification.
Let me enjoy the death at the hand of your lordship. I know it's a judicial mind, I can pursue it. And so, since Mr. Dotto, my learned advocate,
Invocation of the jurisdiction.
basic violation of principal naturality without jurisdiction, the inquiry officer is a bias and run, and
You
his
have taken
action.
all points, Mr. Bose, available.
No, I say, my lord, that it is not, my lord, that judicial review court many a times, my lord, interfered with the decision-making process. Number one.
Yes.
Number
There is
two.
infirmity in the
Yes. Number
decision-making
one.
process,
Now,
yes.
yes, and number two, my lord, the perversity is one of the ground, my lord, and my lord, the without jurisdiction, I am an out of an employment. I have a right, my lord, with humility.
How much
to
time you will take?
My knowledge, my lord, does not permit me to speak more than 10 to 30 minutes.
More than 30
30,
minutes.
35. And my lord, I want to enjoy, my lord, I want to taste, my lord, the Android. I'm feeling, I would love to, my lord, argue before your lordship. And since my learned senior friend, my lord, is here, and I will learn something, my lord. Kindly give me a scope.
For me, it all depends upon Mr. Basu.
30 to 40 minutes maximum. Kindly give me a time.
Difficulty is that
I will take, my lord, only 10 days time to respond.
all right, file
But
an
may I
affidavit in
file it?
opposition. You want to file
Yeah,
reply.
yes. 10 days from today.
Why affidavit in opposition in a disciplinary proceeding matter?
But some allegations of bias are there. Natural justice
Factual
violation.
matters.
You cannot include any document which
No, no,
are
no.
not part of the
No, no.
which were not part of the
No, no.
disciplinary proceedings. Because
But it is so fat, not because of annexures. Pleadings are more than 54 pages.
right,
10 days.
time to file Please brief if it is brief. you can-
I will file a written notes of argument, half an hour and written notes of argument. I will
Post-grade
come
is
with a
the
written
case
notes
of
of
a
argument.
dismissed employee.
Yes, yes. Yeah.
It is what is.
Yes, yes. I'm deeply obliged.
I'm great.
দুটো ডাকলেন না, দুটা? হ্যাঁ? Supplementary টা বেরিয়ে গেছে তো? না, না, please give me one. Mr. Chaturvedi, the item number 2 was wrongly printed. The number has come wrongly in the main list. So supplementary list has also been published. So when can you come? Today? At what time? Can you inform the other side? 12?
Kindly keep it at 12. I shall
Please ask
inform.
your junior to inform Mr. Chatterjee or his juniors.
Lord, I shall ask him.
Supplementary list, it has been published, it will be taken.
Will it be my lord's pleasure to Lord delay it a little more so that delay it
When
a
do you
little
want?
1 o'clock
1 o'clock,
My lord.
all right?
so that
please,
informations can be given.
All right, and Mr. Chaturvedi, you have not handed up the written objection on the last date. But subject to taking instructions whether the correct copy, please supply.
Yes, I have got
Bring a correct copy of that so that it will be taken.
my lord,
because
the copy which was shown to my lord and the certified copy of that my lord has also come.
Let Mr. Chatterjee come
Yes.
because he was opposing that. Please keep copies of that.
Both.
Because I am told that the objection was not filed because I gave it to you for making photocopy.
I'm so sorry.
Might be some, please inform, so 1 PM.
My lord.
Yes, call the list. Item number 3.
Well, I am but the petitioner in this matter.
Well, on the last occasion, my lord, kindly recollects.
No, I am but the petitioner.
Like, kindly recollects.
Appearing under the heading to.
Well, your lord-
On the last occasion, lordship was pleased to direct me to take a date from your BLLRO that when can he undertake the demarcation exercise. My lord, on 19th February, my lord,
It can be done
at my lord 12 noon.
at 12 noon. Yes, Mr. Vadajaji,
Well, I have no objection, my lord.
you are the for the private respondent. An objection
Factor number 4.
Yes.
I had obtained a long-term mining lease for 5 years, and that my lords will be pleased to find the this authority had handed over me possession on 6/11/2015. 6/11/2015, authority handed over me the possession of the land. Now, my lord, in the meantime, I had obtained a notice that is at page 10 of the writ petition, wherein, my lord, there was a direction for closing down of all mining leases of the district of Bankura in terms of a direction passed by the Honorable Supreme Court and pursuant to an order passed in a review application in a particular, my lord, proceeding before the National Green Tribunal. I had obtained the order, my lord, the order of the Supreme Court. Now, and also, my lord, the order passed by the National Green Tribunal.
Yes.
Now, my lord, there was a direction, my lord, for compliance of the conditions according to the West Bengal Mines and Mineral Concession Rules of 26. Then, my lord, it appears I made a representation. That representation, your lordship will be pleased to find. That is at page, my lord, page 23.
Yes.
Now, my lord, at this stage,
What do you want? What is your prayer?
I only want that, my lord, my representation be considered at page 23.
Expert opinion and report of EIA. What is
Yes.
EIA?
My lord, this is
Environment Impact
Yeah.
Authority, Assessment Authority.
now, my lord,
Who will consider this? Corporation?
No. You see, the lease was granted in terms of 2002 rules. As on date, after 2016 rules came into effect, 2000 rule became
Should
it has been
repealed.
repealed. So his representation may be considered addressed to the additional district magistrate and DLLRO. According to the petitioner, lease was executed in April 2015 and possession was handed over in November 2015. So according to the petitioner, there was 7 months delay in handing over possession. For the first time, the representation was made in 2018 and thereafter 2022, 2024.
Now, what is the last document at page 25?
the last document at page 25, my lord. This is also
Representation
a
addressed to the
representation, my lord.
But you want consideration of page 23.
23 and 25, my lord. I say both. That, but only
This
thing,
is for ADM. You are for ADM.
my lord, kindly see the order passed by
Yes.
the
State means the report. What does the report say?
I just now got the report, just.
What is there in the report?
এটা রিপোর্টের কপি দিস রে আমাকে একটা রিপোর্টের কপি দিস
No. Your lease was under 2002 rules.
Milord,
That
I
took
just
repealed in 2016.
Milord, I am
After the new policy in 2021
Milord,
has come,
I just I
and you have
wanted
approached the court in 2026 only.
Milord, I want to show to my lords about rule 61 and 62 of
Effect
the
of
West
repeal.
Bengal minor mineral.
Effect of repeal.
Yes, effect of repeal.
This will not come under the
Kindly-
effect of
kindly
repeal.
consider me- I am just
I am aware about rule 61 and 62.
61. 62 to kindly
That
will
is in-
consider.
in case of
That
grant
lot,
of
the-
fresh lease.
if there, I had a license,
61 is with regard to pending application for grant of lease.
kindly
Here,
see
lease
rule
has already been
62.
executed.
I want to help you, Mr.
No, not
Bhattacharya.
61,
61 is with regard to
62,
pending application.
61
62.
applications, 62,
62, kindly for a second,
yes, yes.
kindly see.
This is the
not
saving
with-
clause.
Yes, notwithstanding such repeal, anything done or any action taken or any prosecution started under the said rules shall be deemed to have been validly done or taken or
No,
started.
one thing, Mr. Bhattacharya,
Yes.
your lease period expired in 2022.
No, to 2019. Lease executed in 2015.
15.
Oh, so 20,
For a period of 5 years,
2020.
20.
So 2020. So according to you, there was 7 months delay.
Yes.
Even if
Deed
that
of-
was is taken into
Oh,
consideration,
2017.
then that would also have expired.
Duwas-
I-
How can that be extended now?
I only say this thing, It is admitted position that Miller, after the West Bengal Minor Mineral Concession Rule 2016 came into force, no action or no fresh action can be taken in respect of the earlier
It
rules.
was saved because it cannot be said because your lease was in force at that point of
I'm
time.
getting-
There's no dispute with regard to that. Even if you are considered under the 2002 rules, according to you, any provisions under the 2016 rules cannot affect your right because the lease was under
It
the
was executed.
was executed under the 2002 rules.
Yes.
Show me that you have a right of extension under 2002 rules at this point of time.
So that-
Then you will be governed according to the sole question submission is you will not be governed under 2016 rules. So you will be governed under 2002 rules. What right of yours is affected? How do you come under 2002 rules? Please show me the violation under the 2002 rules.
No, I can only submit to my lords, Miller, that at this stage, under the provisions of the Rule 62(2), Miller,
No, I accept your submission.
that it
I
has to be
accept your
deemed as
submission that
it has been validly done.
2016 rules cannot affect your right.
But
You can
at
place
this
your
stage,
you can
yes.
place your keys to that height even.
Now, Miller, I
Now,
say,
so your lease or anything has to be considered in the light of the provisions of 2002 rules. Show me the violation of 2002 rules.
so I say only this much that Miller, they have relied, Miller, kindly for a second, Miller, kindly come to the particular Miller notice of closure, which they have issued in 2016. Kindly see this page. It is at
Yes.
page, it starts from page.
I stand corrected. Lease was for 2000, for 2 years. It is apparent from the report. Your Lordship kindly check.
Yes.
Yes.
No, it's for
So
5
whether
years.
have you annexed the lease?
Lease,
You
Lease
have
is
the
not a
copy of
part.
the lease.
If your
Because they
Lordship
say
kindly
it's for
peruse
2
the
years.
report submitted
Then
on
you
behalf
are
of the
gone. 2 years you are gone.
No, if it is for 2 years, I can say nothing. But if it is for 5 years,
They are saying its report says 2
Miller,
years.
I
And you have
say,
also not annexed the lease.
Miller,
Yes, 2 years.
second paragraph of the first page of the report.
Yes, yes.
আমাকে একটা report
Please
দে না।
give a copy of the report.
Sir,
Otherwise,
I am
Yes, yes,
just
sir.
in a dark. I do not know what has been. This is the stepmotherly attitude of the state respondent. I cannot understand. I use a document in the court.
you are a senior advocate. You are also a seasoned advocate. So
No, Lordship, the lease is annexed with the report.
with the report, yes.
Yes. Lordship, it is not paginated. Lordship, kindly turn over
Yes, for a period of 2 years.
Then,
annexure A, annexure
I
B.
say, I
so if
cannot.
it is for a period of 2 years,
Then, Millard, I can only say, Millard, that grant me the liberty to make application under the West Bengal Mineral Concession Rules of 2016.
not
I-
2016 is not there also.
No, 2016.
Not 2021 has come.
No, I did not, Milord, I can only say this much. Milord, kindly grant me so that I can carry on my livelihood and business. I can only
Now, what is the procedure? You have to apply before the
Now, Lordship,
corporation.
as on date, 2016 rules make the process of auction mandatory. In 2002, it was done on the basis of application. In 2016, concession rules, auction rules came into effect, which says
You can be-
mandatory.
You can participate
Nowadays,
the
in
auction.
terms of 2021 rules, the mineral development, they usually floated a tender for empanelment. And when the auction was conducted for grant of mining lease, only the empanel candidates, they are
So they have to first empanel
empanel themselves.
Have you followed? Have you, because now the 2021 policy
Troops
has
has come and the auction,
now auction is a subsequent stage. First, you have to get yourself empaneled because there is a list. Auction will be done within
in
those.
respect of those,
As in other authorities, the only enlisted contractors are entitled to participate and other things. That's the procedure. So first, you have to get yourself empaneled. Without that, you cannot also. I cannot also allow you to participate also.
then Milord, kindly give me that,
I can give you liberty to take appropriate steps.
that may not perhaps be
Because
very.
empanelment, you have not.
That is subject to
have to-
fulfillment of criteria. You have
I do not
to
know whether you
I say, Milord, that permit me to make an application. They will scrutinize as to whether I fulfill
application
the
for what?
criteria for empanelment of my name. For
Yes, what is the procedure
participation
for
in the-
empanelment?
because
if they
this
can
is in the
submit an
dark.
application, it will be done as and when it will be put into auction for empanelment. He can file the application, the authority,
Empanelment is also for.
it is also for auction, through auction process.
Mr. Bhattacharya, I think please go through the provisions. Otherwise, no effective.
Or Lordship,
any order
he can
passed may not
submit an
be-
application, we will inform in detail the procedure for empanelment.
Or I can do one thing. I can. He has made a representation to the ADM. I
ADM
direct-
can dispose of,
direct disposal of this. The procedures.
indicating the up-to-date procedure for
Yes, that
empanelment.
Miller kindly do because they will reject it. And therefore, Miller, I have to be given because
Election, as
this
we
is
have heard,
automatic.
it's
Yes,
only a
this
matter
is-
of courts now.
yes,
But,
this is now an ideal formality. This is now an ideal formality. But Miller, at the same time, Miller, kindly grant me that much so that I can earn my livelihood.
The petitioner Report taken on record. Yes, next.
And in item number 5, I am appearing for respondent number 12, 13 and 14, my lord.
My lord, I beg to appear, Lordship. I am for the petition.
The private respondent. When I raised a point yesterday that on the same issue, the petitioner moved the writ petition, then got an order that has been entirely suppressed in that writ petitions. And kindly see this order first. Any questions, sir?
Mr. Dotto, do you have an extra copy? Please give it to him.
Well,
Yes.
my lord, kindly see the cost title and another different cost title. Co-sharer Akbar Ali and Uttam Kumar Vera is co-sharer, Lordship. My lord, made application before the
Petitioner number 2 is Sheikh Akbar Ali.
Lordship.
So he is not the petitioner in 21004.
Uttam Kumar Vera not.
Second, maybe Uttam Kumar Bera, but another petitioner, both have jointly filed.
Yes. And he has filed the affidavit.
Lordship.
Please number 1.
Who has affirmed this?
Uttam Bera.
Yes.
And he is acquainted with the facts of all facts of the case.
My lord, made a application before the concerned authority. Unauthorized
Yes,
construction.
State.
Unauthorized.
What is your instruction? But the previous, the court directed to take steps. What steps have you taken? Ashok.
Only one thing only. So for these,
You are the private respondent.
only one thing only I will make
Mr. Dotto, there was a direction in the earlier writ petition. There was a direction upon the authorities to take action.
But this case has not been made out in the writ petition. But kindly visualize these things. But if he filed a writ petition containing inter alia that the earlier order has been passed, the authority did not take any action. This is otherwise. But this writ petition has been made out with some other facts on the same plea.
What be the other facts?
So other facts, my lord, this petition has been made out with the same prayer.
Have
with
you
the same
encroached upon a PWD road?
But-
Have you encroached? If you have not encroached, so let them file a report as to whether there is any
No,
encroachment.
only one thing.
Mr. Dotto, if there is any encroachment, you
But
cannot.
this is otherwise. I am telling you, this is otherwise. But this representation is not maintainable because I will be producing.
Let
No,
the
I will
let
be
the
producing.
report.
Kindly see, I will be producing a Supreme Court judgment. If the suppression is made before this court, that amounts to a fraud before this court, and the petitioner cannot get any relief. Kindly see this judgment.
Mr. Dotto, even if the petitioner cannot get any relief under 226, I can direct them to remove encroachment. That can be done.
But that can be done
That can be
on
done.
the basis of not that repetitions.
That I will consider.
That repetition.
That I will consider.
Private.
Then my lord,
If you are,
if you want to hear the merit of this case, then I will argue the merits of this case.
yes, I'll go on the merits.
Uh,
Yes.
Now kindly see,
Yes.
first of all, kindly see they have annexed this deed.
Yes.
Kindly see this deed.
Page 31, yes.
And so also seen this deed. Next page,
Yes.
page 5.
Page 5, yes.
2, 3, 4 pages has not been incorporated. First page, kindly see. The second page, page 5. Who will be the owner? Who is nothing of this reflected on that deed. And page 31 also.
31 already been.
Yes.
Page 35, kindly see. Page 35.
Page 35, yes.
Deed, first page, second page, page 6.
Yes. Why have you not annexed the entire deed?
Mistake. What mistake, Lord?
Now, this is the point. Second point. Now, kindly see the act. The act of the
Which act?
PWD Act.
Yes. PWD Act.
Yes, sorry.
Western
PWD
What
Act.
are the Highways Act?
Highway Act 1964, Lords.
Kindly see.
Yes.
2 C.
PD.
2C. Highway means any government road or any other road, street, pathway or land other than national highway within the meaning of the National Highway Act, which is declared by the state government to be a highway under section 3. Now kindly section 3. The state government may by notification in the official gazette declare any road, street, pathway or land to be a highway. Now this road is Kochuberia to Gangasagar. Now by virtue of section 3, notification was issued in 2020 15. Kindly see this notification. That road was included in state highway. I am giving that.
Yes.
Last. Last.
Kochuberia Gangasagar Road, 20, yes.
Now, my lord, the highway authority was also there. So who is the highway authority? Now, 2017 notification.
No, this is notification of 2015.
2015. 2017 notification, I am giving that.
Yes.
This road has been excluded. Kindly see. 24 Pargana. That is notification now. কোথায় দেখো রাখো?
South 24 Parganas.
Has you also got it?
Yes, South 24 Parganas.
SS State Highway 3A. State Highway 3A. No, second page. Third page. You also got it?
Yes, is what you are trying to show from here?
That State Highway 3A has you also got it?
Yes,
South 24 Pargana, Science City to Ghospur, these are the state highway.
yes.
But this Kochuberia to Gangasagar has been excluded from the 2017 Act. Because kindly see the notification first. Notification. First, I am reading that notification, 2017 notification.
Yes.
A list of state highway West Bengal has been notified from time to time recently. A few stretches of the existing state highway have been declared as a national highway. Moreover, in intervening period, different stretches have been developed to serve as a state highway. Hence, revision of the list state highway is felt necessary. The governor is therefore pleased to notify the list of state highway in West Bengal on such and such in the interest of public service notification. The notification is issued superseding all these previous notifications. Therefore, 2015 notification has been superseded. 2017 notification has come into effect. When this road was included in the 2015 notification, now when this 2017 notification has come up, this road has been excluded. Therefore, applicability of the West Bengal State Highway Act 1964 cannot be done.
My lord, Gangasagar to Kochubelia Road maintained by the PWD, maintained by the Assistant Engineer and Executive Engineer Diamond Harbour, Kakdeep.
Sir Doctor, please kindly come to section 2 within bracket BB.
My lord, BB.
Here the government road has been defined.
Yes.
Means a road vested in the government
Yes.
or under the control and administration of the Public Works Department of the state government and includes what it includes, it says. Please now kindly come to 2C. Highway means any government road or any other road. So any other road declaration is with 3, government road is within 2B. This is inclusive.
That must be.
This is inclusive. So I've delivered a judgment on that also.
I know you lost. Only one thing, my lord.
It's not
No,
since it's outside the jurisdiction of.
No, outside no. I am making the submission by virtue of that section 2C. Whatever the road that must be gazetted.
This government road sees or.
Or
Because-
I am reading that.
Yes.
Yeah. Any government road or any other road, street, pathway or land other than the national highway within meaning of the National Highway Act, which is declared by the state government to be highway under section 3.
1 and 2 is or disjunctive, Mr. Dutt.
Yes.
So under 2, it's declaration, not 1.
But declaration to be done.
Let them say it's not within. I'm calling for a report from them. If it is without their jurisdiction, beyond their jurisdiction, they will not take any steps.
Let them report the whether this is highway or not, as per section 3. And the road is, my lord, recorded district board.
Mr.
Now
Dotto,
maintain PWD.
That
owner is the district board,
Ah.
but that's not sufficient.
But-
It's under the control of whom? If it is, even if it is owned by the district board but maintained, controlled and administered by the PWD, it comes within 2BB.
Yes, but that is to
Let
be
them
notified.
say,
Let them say.
district board, all roads which are owned by the district board, in most of those roads are controlled and administered by that.
I understand, but that must be notified.
Ownership from the record of rights, you can produce the record of rights. Those are the documents you will be producing, showing that, look, it is in the name of the.
But I understand, my lord, but that must be notified.
My lord,
Let
private
them
respondent.
Let me call for a report.
My
If
lord,
it is
my
beyond the jurisdiction of the highways, 1964 Act will not apply.
My-
But let me see what can be done. But if on any government property, you cannot encroach upon.
And that will be coming under C22 Act.
My lord, private.
That is a
But
different,
this act will not be applicable.
that is a different thing
A
altogether.
different thing.
That is a different thing altogether. Yes.
Can you come to paragraph number 3 of the report?
Paragraph number 3 of the writ petition. Yes. Who are you?
Only number 16.
You are also an encroacher. Alleged encroacher.
Yes, we have made encroachment on their club, not on the government.
Paragraph
Three.
3.
Paragraph details of the-
My lord, private respondent no right to title made the construction on public premises, no right to title.
And details of the location upon which the unauthorized construction has been based and in going on at Gangasagar to Kochi.
Paragraph 3.
3.
Yes, the details of the
The details of location upon which the unauthorized construction has been raised and in going on at Gangasagar to Kochi main road, go down the near about HON'BLE in front side HON'BLE bus stop under petitioner LR plot number such and such, which is adjacent to PWD LR dark number such and such, classification of land.
no, if your construction is encroaching upon any Rayati property, that cannot be removed under this act. But if it is upon the, let the report come, everything will be clear. Ashun, the petitioner. Paragraph 3.
That is his prayer.
My lord, unauthorized construction on PWD land.
What is the number of the, what is the plot number of PWD road?
2684, 3689, 3687, lordship.
Then thereafter, what you have said? Classification of land, Shali, Bastu,
Yes.
everything, measurement, such and such. confusing statement in paragraph 3.
My dag number Salian bus. My Radland dag number Salian bus.
Paragraph 3 does not carry any meaning. Please withdraw it, file afresh.
My lord, same paragraph made in my paragraph number 2 also, my lord. Kindly see paragraph number 2. What is the meaning of paragraph number 2? I didn't find.
You're confusing. The
Yes.
yeah,
My lord, kindly see the 25 page number.
25 years.
Dag number 3647, District Board, South Chobbish Pargana. Classification of blood, loin jolly. And 26 page number 3648, classification of land. Rasta.
What have you done? Statements in the paragraphs, this carries no meaning. And you have also not annexed all the pages of the.
My lord, kindly see the 28 page number.
Sir, these are annexures in support of the pleading. Please take some responsibility to draft the writ petition in a proper manner. This is not the writ petition. Annexures are not the writ petitions. These are documents in support of your pleadings. You have also not annexed all the copies, all
Lord,
the pages of your deed. Please withdraw this file afresh with the petitioner.
Kindly be noted that there is been suppression in the.
लिखा दिन, Mr.
এই অর্ডারটা দিয়ে দেন।
অর্ডারটা দিয়ে দিন ওনাকে।
Grateful to your lordship.
Let's call the next matter.
Matter number 6.
My lord, in this matter, I'm for the petitioner, my lord. Service not complete, my lord.
Yes,
Like 2 weeks time, my lord.
6. What have you prayed for?
2 weeks time, my lord. Service not complete, my lord.
No, what is this matter?
I don't know idea, my lord. Mr. Gautam Banerjee appeared for the petitioner, my lord.
The learned advocate appearing for the petitioner submits.
Madam, for the petitioner, my lord, led by Mr. Roy, my lord. He's on his-
Yes.
Dada. My lord, the petitioners, my lord, initially, my lord, purchased the property, my lord, and got their names, my lord, successfully recorded. After that, my lord, the petitioners were threatened, my lord, by the BA, my lord. Calls were made, my lord, from their office, from the office of the BLLRO, my lord, that you come here and you write an application that I don't want my names to be recorded, and I'll change the entries to be recorded in some other person's name. Now, my lord, the petitioners at that instant, my lord, filed an application, my lord, before the police authorities, my lord, and filed an writ application, my lord, to compel, my lord, the police authorities to take steps in terms of that complaint. Now, my lord, in the meantime, my lord, the record of rights has already been changed. No information, nothing, my lord, given
That
to the.
you have to challenge before the.
My lord, my lord,
tribunal.
my lord, kindly, my lord, considers, my lord, the order passed by your lordship, my lord, a few days back. Not I'm carrying the order, my lord.
But
My lord,
Another dispute is also pending, my lord.
হ্যাঁ বলেছি সেটাই হচ্ছে almost similar case, my lord. My lord, no information given, my lord, to the petitioner. When was no hearing given? No hearing given, nothing. The petitioner suddenly finds, my lord, that the record of rights have been changed.
It is exclusive within the domain of the LRTT, my lord.
not a final decision.
Yes, kindly, my lord.
Sir,
My lord, no, my lord.
Pending.
My lord, yes, that application is pending, my lord.
No,
My
no,
lord,
no.
kindly considers, my lord, this the case here, my
The
lord.
hearing has been concluded, and your learned senior, I think, is not coming. For that reason, he knows the fate of this.
My lord, decides the fate of it, my lord, together, my lord. Otherwise, my lord, kindly seize the application, my lord, kindly.
Nothing.
My lord,
Let's ask.
my lord, kindly seize my application once. My lord, kindly seize, my lord,
Yes,
kindly take
yes.
sir.
The prayer is.
My lord, I know the prayer, my lord,
Taken action against the. This is your main prayer. If you are withdrawing
Prayer
that,
two,
nothing
my lord.
remains in the writ
prayer
petition.
2, prayer 2, my lord. Prayer 2.
Prayer 2, yeah, I'm
Second
looking.
prayer.
I'm
My lord,
only.
kindly take some, my lord, my lord, kindly take some, my lord, page 57 once.
Yes, page 57 once, yes.
Starts at, my lord, page previously, my lord, my lord, page 57, 58, my lord, sees, my lord, the Rayatan Nam.
Yes, yes. It
Right,
has been
and
changed.
Yes, Kaje Mondol.
Yes, yes.
My lord, kindly sees, my lord,
Yes.
My lord, I am appearing for the petition.
Yes.
My lord, here the grievance of the petitioner that the petitioner made an application to the concerned authority to record the name of the petitioner in the record of the land in the leasehold property. That is actually, my lord, this is a leasehold property, government granted lease for 999.
Where is
In
the
the
order? Where is the order rejecting your prayer for petition?
49, page 49, my lord. Kindly see page 49. What is the taken? That is the illegal transfer. But I think, my lord, in the deed, there is no clock or restriction imposed by the authority not to transfer the property. So, my lord, I have annexed this document also. My lord, kindly see page 49. In compliance with the order, may I read it?
Where is the original lease deed?
My lord, I have annexed
Page,
original lease deed, my lord, page, kindly see page 23.
page 23.
Starts from page 20 and 23 is the clause.
Sir, what I am showing your lordships.
Page 23.
Yes.
Clause 6.
Where is the power to transfer?
Not to assign,
Underlay
underlet, or part
with-
with the possession
Yes.
of the demised premises or any part thereof without the first obtaining the written consent of the lessor. Such consent, however, not to be unreasonably withheld in the case of a respectable and responsible person. My lord, here I have made application in the year 1998 and this rejected 2003.
No,
So,
but where is the subsequent transfer deed?
my lord,
You have transferred, it was
29.
transferred in your favor. When?
yes, page 29. The original lessee transferred the property to the petitioner without getting the, in terms of the court's order. Court passed the order. If the time lapses, so the registering authority can register the document.
Where is
Page
the court's
30, my
order?
lord.
Where is
Page
the court's-
30. Page 30, my lord. Page
30.
30. At top, my lord, kindly see. Presentation accepted.
Where is the order passed in that writ petition?
This writ petition.
Yes. This was passed pursuant to an order passed by in a writ petition.
Bhaskar, what is it?
Yes, yes. Where is
My
that?
lord, my lord, that order I have not
Yes, sir.
at
If it is
present.
pursuant
my
to an
lord.
order passed by the writ court, how can you reject the prayer for mutation?
No, we have rejected.
Not only this, my lord, several order passed by this, your lordship knows that.
My lord,
That there is no clock or restriction imposed by the government in the original lease deed. So,
There is a restriction. Without permission, you cannot.
Yes, my lord.
cannot.
my lord, several,
There was restriction.
but I have sought for
How can you,
permission.
As per clause 6 of the my lord lease deed, my lord.
There's a court's order.
Yes, my lord.
Presentation accepted.
Page
Where is this
53.
order?
My lord, we have rejected the permission fees. That is at page.
That is not
My lord.
applicable, my lord.
But
After
page-
the court's division bench order, that is not
On
applicable.
what ground we have rejected, my lord? They
My
have.
lord, page
This
53,
was-
kindly
Have
see.
you seen page 30? This document was registered pursuant to an order passed by the court.
Yes, my lord. That is, my lord, so far as the transfer is concerned, there is no problem, my lord. Only, my lord.
If the transfer is, there is no problem. How can you refuse
But
mutation?
they have not taken the my lord, permission from the authority, my
No,
lord.
no.
Court allowed
Page,
this.
page 53, my lord, kindly see.
You above the court.
I have sought permission, unreasonably withheld.
Permission you have not granted. You sat tight. Court directed this registration. You are above court.
No, my lord. My lord, before.
Please see page 30.
Yes,
What is
my
your
lord.
instructions on this?
But then I have to take instruction. I have not received instruction. Today morning I have received the brief, my lord.
Please see presentation accepted in view of the register accepted this document in view of this.
On this point, I have
And
to
he has applied. It is not your case that
Page
he has not
53,
applied.
my lord, kindly see
So
page
if you have applied, you will take unreasonable time.
But we have rejected, but that rejection or they never
However, not
challenge.
to be unreasonably withheld, this clause is there.
But
In
that,
case of a respectable and reasonable person, and there's a court's order also.
but that course order I have to see, my lord.
When can you come back with instruction?
My lord, 2 weeks. My lord.
But that is also, you have also not taken into consideration the court's order in the impugned order. That was also not taken into consideration.
But next day I shall show your lordships this order also, and along with the others order.
Petitioner. Call the next matter.
Number 9, I am for this petition, my lord, led by Mr. Mustafa, my lord.
Yes.
I am for respondent, Lord. 3, 4, and 5.
So for the private respondent,
No, Lord, Jila.
Jila Parishad, my lord, the petitioner paid for long-term lease, my lord, by the Jila Parishad. In this regard, my lord, earlier occasion petitioner moved a petition, kindly page 16. Bottom portion, my lord. Page 60, my lord.
yes,
And an advocate appearing for the state respondent 1 to 8 submits that the writ petition is incompetent today because the approach has been made to the appropriate authority for grant leave. By this way, my lord Justice Om Narayan Rai, my lord, grant leave to proper application, my lord. Page 18, my lord. Kindly consider the representation.
yes.
Page-
What happened after that?
Page after that, my lord, page 18, phrase representation is made, my lord.
Yes, what happened after that? They have not taken any steps.
No, my lord.
Lord, what happened, Lord? I have told for phone, Lord, I have not, Lord, records with me. The Jila Parishad, Lord, disallowed his prayer for long-term lease.
Has disallowed.
Disallowed his long-term, Lord, in meeting, Lord.
So you communicate the decision then.
Lord.
No order passed, my lord. No hearing and no order passed.
Lord, they are, Lord,
Communicate if you are aggrieved, you can challenge that. The petitioners,
Kindly consider the representation, my lord.
he has considered rejected, sir. I am directing him to communicate the order. The
meeting.
Led by Mr. Galib, Lordship.
Your Lordship, I am for the petitioner. I am led by Mr. Shobhusai Chatterjee. Your Lordship, he will appear in this matter, but he is in Delhi today. Your Lordship, I am praying for not to.
You are here.
Lordship, read it not maintainable, Lordship. Finally, see the prayer, Lordship. For record of rights, Lordship. This is the separate forum, Lordship. Prayer A.
Your prayer for correction of the record of rights was rejected.
Yes, Lordship, but the order of CR 3592 of 1982 is in favor of us, Lordship. Page number 42, 44 is the order of CR.
How can you challenge an order passed in 2008 in 2026?
Lordship, I have made several representations,
Maybe
Lordship.
that does not cure the limitation. Making representations does not cure limitation.
I made several representations, Lordship, and
that does not cure limitation.
Lordship, I am paying for a single day accommodation, Lordship, in this matter.
If you want, you can approach the tribunal. The petitioner
Effective service, my Lord.
Yes.
My Lord, without acquisition, the land of the petitioner.
I am afraid on behalf of the state.
Flag number Gram Panchayat forcefully construct a concrete road over the petitioner plot of land.
constructed or they are going to construct.
No, constructed. Page 41, my Lord, representation. Page 41.
Yes, what is your instruction?
I have no instruction. I have to take instruction. That's why I'm paying for it.
Page 41, my Lord.
Yes. What is your decision on this representation?
I have no.
Wait, the petitioner
I need some time.
alleges
I am for the petitioner.
yes.
My lord, the land of the petitioner was, my lord, acquired and my lord taken possession in the year of 1982.
Year
82.
under what act?
Under Act 2, my lord.
Yes,
Lord,
then
thereafter, my lord, after expiry of 43 years, no compensation has been, my lord, paid. My lord, kindly see page
acquired or requisitioned?
no, my lord, acquired and taken possession.
4-1A done.
My lord, kindly see page 20, my lord. Kindly see page 20. 21 is the finding, my lord. And estimated under section 93B amounting to rupees 1,90,000.
93B. So after 4-1A.
Yes. Lord, and estimated under section.
Mr. Dutta,
But
what
I
is
have
the
seen,
instruction?
I have seen the brief, my lord. My learned friend is right, he is entitled to compensation, my lord. It is right.
Yes.
But my lord, 1982, they first approach in 2012. First approach, then 2023. In the meantime, they were also sleeping.
No, my lord.
20.
It is your duty.
My
When you are
duty-
utilizing,
Right.
you cannot utilize without payment.
I cannot deny they have to
You cannot
pay.
take the point of limitation.
No. I am not raising any question, my lord. Your lordship, they filed this representation, last representation in 2025.
So showing that you want some more time
My lord,
to take
you
instructions.
also can direct that representation, they have already, my lord, also the government has taken steps.
My lord,
You know,
kindly
you
see
find
page 20, my lord, the special land
Page
acquisition
20,
officer,
government has taken steps.
Page 20.
Page
page
20.
20 and 21.
Now, have you paid?
No, no, the
Mr.
special
Doctor,
land
if you have
acquisition
not
officer.
paid, this has become infructuous
Right.
now.
Your lordship, their last representation they filed, that should be considered within a certain time.
What consideration?
No, no,
Making payment. Making payment.
Show me the award.
And
special land acquisition officer, my lord, already taken,
Now,
seeking
payment
approval.
cannot be done under 9(3)(b).
no.
It's under 2013 Act now.
And
Right to fair compensation, my lord.
my
the
lord,
entitlement,
there are
my
two
lord.
modes, my lord. There are,
My lord, that was
the
mentioned in the
authority-
my lord order.
authority, after considering his representation, may request them to direct purchase policy. Direct purchase policy may be adopted, and if they accept.
Not may.
No.
Are you offering direct purchase policy? You have to state that
No, no.
by way of an affidavit.
No, I have not.
If you are offering direct purchase policy, state
No.
that by way of an affidavit
My
that I am
lord,
offering direct purchase policy, and within how much time we will complete
my lord,
that proceeding.
today I have no instruction.
And
Just,
the price also.
my lord,
You will say direct purchase policy, then you will quote a market price which is far below the market price.
I cannot argue your lordship settle this matter. Your lordship pass this judgment. Lordship settle the matter. I cannot say anything. Just today morning,
Come back with the instruction, Mr. Doctor.
my your lordship kindly, the last annexure, they submitted representation in 2026 January.
My lord, kindly see page 21, third point, my lord.
আমি তোমার deny করছি না তোমার কিছু. He is right. His land is being utilized.
Mr. Doctor,
But I cannot say anything more, your lordship.
of a person who has lost his property, not getting
Your lordship
compensation.
decided this matter on several occasions. I cannot say anything. This is legal.
How much time you want to take instructions?
This person, special land acquisition officer, is connected with SIR.
Don't take that plea. SIR will be over within 1 week. That's as per the Supreme Court.
But in the combined monthly list of March,
Not combined. As per the Supreme Court decision, hearing will be completed within a week.
2 weeks time.
Extension of 1
2 weeks time, we kindly grant.
The petitioner alleges আচ্ছা, ওই বললাম যে to file a report and প্রায় বলতে পারেন advance
You also decided the matter many times.
please look because
Right. I guess
if your instruction is direct purchase policy, please state it on affidavit because unless you offer
no.
that,
without
My lord,
instruction, I can
already,
see.
already special land acquisition officer seeking approval from the additional secretary.
after
for
5 minutes.
Right to
of the petitioners, Lordship, here what has happened, Lordship, a mutation has been carried out in favor of the private respondents. Lordship, I made representations before the concerned officers that I may be afforded an opportunity of hearing that has been kept pending. Lordship, I am praying for consideration of that
The
representation.
cancellation of mutation, my lord. My lord.
My lord,
In
what
my
my
lord,
senior friend is saying, Lordship, had it been my prayer that mutation be cancelled, Lordship, but here I am only seeking consideration. of it.
Inaction.
inaction. The tribunal,
That
he
is
has
also
to
covered.
approach the
That
tribunal.
becomes very onerous, Lordship knows.
No honor. That's the statute.
I
Statute.
understand, but
Ashun. The
I'm appealing for the state respondent.
My lord, I appear for the private respondents, my lord.
এটাতে তো
land measuring about 19 decimal in plot number 230. Just want to inform from my land, 10 decimal land was purchased by one Subhash Nair, and he has gifted the land in favor of the private respondent. Now, subsequently, that to 10 decimal land was acquisitioned by the Irrigation and Waterways Department for widening the Odisha Coast Canal. Now, after that, now the private respondents started the construction over the irrigation land just in front of my land. That's why I made a representation before the authority, my lord. Page 27.
I appear for the private respondent.
Private
The land-
respondent.
Fine.
You are for the state.
State, my lord. Land
Yes,
was
what is your instruction?
not, yesterday I received the brief, not no instruction as
Only
yet,
one
not.
submission, not. Land was converted not from Jol to Bastu. They have annexed not the record of right which shows Jol. We have converted not 2009.
Jol
to
is
Bas-
agricultural, it's Mendipur.
My lord.
Kontai, yes.
Kontai.
It's agricultural land.
land, Jol Jom. I converted, it was converted to Bastu. And not then construction has been made in 2000, after that, not 2009. We are paying Khajna till date. This is the not Khajna receipt.
Now, whether the land belongs to irrigation and waterways
Is their
department,
allegation.
that is to be looked into.
For the acquisition, they have to show the
Let
land
them,
as an
let them
acquired.
make this inquiry whether
Let
land
them-
belongs to irrigation and
Let
waterways
them file the
department.
report.
My lord.
I say it is not an acquired land.
Yes.
In 76, 77, some proceeding was initiated which was never completed. Let them not file the report showing that notification and award was passed.
I can direct the,
Then they would
let
not have not converted the land.
let the irrigation and waterworks department consider this. I will
Only one thing, my lord. They have to not show my lord that acquisition is complete because kindly call for a report because in 2009 conversion is made. They are saying that
authority can decide on that.
76, 77 acquisition was done. Then they would not have converted the land in 2009. Let them not show at least what is the your lordship knows most of the cases not they issue the section 4.1 notice and take possession, but they never complete. If they can show that it is completed, not then I have nothing to say. They have to show that.
Mr. Banerjee, there is one thing, if it is not completed and other things, you are the subsequent purchaser.
I have purchased in 1996.
So proceeding
Conversion at my instance.
No, conversion is one.
If it has lapsed, my lord, then it is gone in the eye of law. If it has lapsed.
Yes, he is not challenging the acquisition. You are also not challenging the acquisition.
We do not know whether it is acquired or not. No material is before your lordship.
And that's why the authority will take a decision whether the land has been acquired by the irrigation waterways
If
department.
not today they say it's an acquired land, then I should get a chance to challenge the acquisition.
Yes.
That is why I am saying let them not show. Otherwise, within 2 weeks they will pass the order of
the petition. Yes,
15 my lord, I am appealing for the petition.
yes.
My lord, here the land of the petitioner has been acquired for my lord construction of a.
Compensation not paid.
No. My lord,
Malad, no case number, nothing.
that
It
is
the allegation is that the railway has taken the land.
for
Railway has issued the notice.
made after filing of the writ application. My lord, this notice has been issued by the special land.
There is no acquisition proceeding.
My lord, this was. My lord, the
No
petitioner has
acquisition
not
proceeding.
issued, only one copy has been published. On that, my lord, notification, the land of the petitioner, my lord, has been acquired. From that notification, the petitioner came to know.
Railway is the requiring body.
I served the copy of the writ application to the officer. And land, my lord, already used by the
No case number, nothing, total vague application.
petitioner at all.
If
You have to give your plot number.
My lord, that was shown in the notification. If your lordship kindly see page 46, page 45 and 46, page 45, if your lordship kindly see for a
Your
moment.
plots are involved.
Yeah, but that plot 107, the serial number 107.
Malad, this is part of the paper. This is part of the paper cutting.
Yes.
This
Yes,
is not
that's the
no
notification.
case, no notification, case number, nothing.
Page 100, serial number
Your
107.
office will be
My lord, my officer requested the railway authority to give anything. Nothing
Railway is the party.
Yes,
Railway
I
is the
made
party. Unless the my lord railway furnish that whether the land has been required or not, it is requiring body is the railway.
and 3 plots had been taken in the from the gazette notification. That notification the petitioner came to know. Page 45 and 46.
Where you have not implicated the railways as a party.
Yes, my lord, I made
Where? Which respondent? You have not implicated. Competent authority for land
my
acquisition.
lord, 7
7 is the competent authority for land acquisition.
Eastern Railway.
No, the competent authority is the special land acquisition officer.
So that is not the railway is to be party.
Leave may be granted. I served and come back.
The Mr. Mahatal on it, additional government.
March motion লিখে দাও।
Yes, Mr. Rai.
এই নাম্বারটা
Yes.
In this matter,
Proceed, my lord.
but the earlier occasion I moved before Lordship that they all on a sudden change the record of rights. Lordship passed the order, this should be sent before the tribunal.
Yes.
No matter what they have done now, page 46, your Lordship kindly come. Immediately they serve a notice, Lordship kindly come to page 46. But this is my land and my Adachak is there for a long time. They say unauthorized, but with the sanction of the local municipality, I am running this for a long time. Now I don't know whether they have acquisition or requisition. No section 9 notice was never served upon us. In the earlier occasion,
My lord,
twice
this
they have
matter-
done.
Wait,
Bolo.
this matter was moved before the Lordship, my lord, earlier occasion, my lord. There's a
Yes.
page 44, my lord.
Yes. That was erroneous recording in the record of rights.
Right. So, my lord, there is without same cause of action, my lord, file another writ petition, my lord. This-
Same cause of action.
Here is challenging now the eviction notice,
Yes.
not the same cause of action.
There's a page 46.
46 is challenging now. Have you implemented the railway authorities?
Yes, ma'am. Yes,
Have you
yes.
served?
Land fees appearing. Land fees for the.
No, no,
That's
it's
what
for
the
the
state.
state.
My Lordship can see page 2, 3 and
Where is
4.
the evidence service? When have you served?
I have served by registered post.
When they have received?
Today I have not got it. Now,
Then, unless it is served, how can it be taken up?
I have served on 5th.
You have sent on 5th, not served.
And
The
really well.
or 17, my lord. In this matter, prayer is very innocuous. Claim for compensation in respect of where my constructed house is there on the basis of
National
the
highway.
national highway. I made an application, my lord. Page 33, your lordship kindly come. An representation has been made. Let it be considered by the authorities. Yes, my lord.
The petitioner alleges new motion. 91, yes.
Lordship, I am for the petition.
Yes.
Lordship, in this matter, the Honorable Coordinate Bench passed a series of order. Kindly see, Lordship. Lordship, Honorable Coordinate Bench also passed order first 10th of January 2024 by directing the State Responsible Authority to prepare report, which was subsequently submitted 19th of February 2024. Respondent number 6, State Respondent Authority. And thereafter,
Yes, what is your, what do you want?
Lordship, in this matter, I am challenging the proceeding because the respondent authority first initiated, first sent notice to the petitioner where the respondent authority clearly stated that for the purpose of pharmaceutical project, to construct the pharmaceutical project, they intend to acquire the property and they actually determine the amount. Only first notice has been given. Thereafter, Lordship, the some meager amount given.
Affidavits have been filed.
Affidavit in the form of Lordship report in the form of affidavit has been submitted.
Affidavit and reply has been filed. Affidavit in opposition has been filed.
All has been filed, Lordship.
Yes, it's a hearing matter. Why it's appearing under the
Lordship,
hearing motion?
on the last occasion, can you see the order, last order,
Yes.
11th of March 2025, where
Says
the
for orders.
for order it has been.
Orders, it cannot be. That bench heard this matter. I have to hear it afresh.
Lordship,
Ashun.
only my prayer, Lordship, kindly fix this matter on any day, Lordship.
Yes. Yes, who is for the petitioner?
My lord, Devanita Pramanik, my lord.
Where is he?
নামটা দিতে হবে। আমি respondent আমি কিছু বলি না।
Yes, what is the instruction?
My lord, in this matter, my lord, he's agreed with the compensation, my lord. But he's asking for the compensation, my lord. Well, he's the state, he's the actual respondent, the answering respondent, my lord.
Yes, he's agreed by the compensation.
My lord, he's asking for the compensation, my lord. He said his land has been forcibly taken away.
Compensation has been determined.
My lord, that have to take the instructions, my lord.
Where is the brief report? Where is Mr. Soumitra Bandyopadhyay? Yes, you are here. You assist Mr. Bandyopadhyay. Please come here. Where is he?
There.
You come here. Yes. Yes, award was declared, everything done. Where is the petitioner?
Mr. Suman Basu is appearing on behalf of the petitioner. One of the requested made by the take a short pass over in the back.
All right, pass over. Next.
Yes, sir.
Yes. None appears for the
My lord, I appear for the writ petition.
just 94 yes.
My lord, this is a peculiar situation where I question the legal sanction behind the notification acquiring a property, which is at my lord page 40. If my lord takes.
Who is for the state?
My lord, the metro railways will be the.
Oh, metro. Who is appearing for the metro railways?
Was appearing before the Metro Appellate Authority. My lord, I'll tell you what has happened.
Yes.
A property was sought to be acquired under the Metro Railways Construction of Works Act 1978. Section 6 notification was issued, Section 10 notification was issued. Under the Metro Railways Act, once the notification under Section 10 is issued, the property vests. Thereafter, my lord, award was passed. Metro filed appeal. During pendency of the appeal, they first tried to get out of the property under Section 30 of the Metro Railways Act, which
de-requisition
the property under Metro Railways Act. Thereafter, they took recourse under Section 93 of the 2013 Act and said that this property is de-requisition. Now, the question is, under Section 105 of the 2013 Act, the provisions of the Act do not apply to Metro Railways. We are as owner, I am owner of the 50%. I think my learned friend is owner of the balance 50%. Now, we are only concerned with the fact that once the property had vested in the state, whether it is lawful to.
So you don't want the property?
I want a clear title. Malad, it cannot happen that 10 years down the line when we try to sell the property, this issue comes up.
Where is the decision for release from acquisition?
Malad, page 40.
40.
That is the notification, my lord. The English translation of the same notification
is that translation. Why?
It's first part is in Hindi and second part is in, as it happens, my lord.
In the notification.
In the notification.
Yes, withdrawal notification.
Withdrawal notification, my lord. This premises number 2/2 Judges Court Road, PS
Premises number
2/2 Judges Court Road. My lord, third line at the end.
Yes. Premises number 2/2. Yes.
So they want to withdraw from the acquisition.
Yes.
Now, my lord will kindly take the Right to Fair Compensation Act, Section 105.
Revoke the impugned notice. What is the notice? What the notice is this? 10th of.
No, my lord. Notice is 1st of February 2018. This is the Section 10 notice.
No, your one of the prayers is to withdraw this 10th of March.
10th of March.
Or to set aside this 10th of March. That's the notice you are challenging.
Yes, my lord. What they have done is, the following land was previous, my lord, the fourth line from the middle, the following land was previously notified in Extraordinary Gazette of India.
You should be happy that they have left.
I want to only ascertain whether, given the land was vested under the Metro Railways Act 1978, Construction of Works Act 1978, whether and Section 105 of the 2013 Act.
2013 Act. Yes.
My lord, may I hand over?
100?
105. অন্য নোটিফিকেশনটা কোথায় আছে বার করে রাখতো 105 এর একটা নোটিফিকেশন ছিল না আরেকটা ছিল না যেটাতে বললো যে পোরশন অফ ওই কম্পেনসেশনের প্রভিশনটা অ্যাপ্লাই করবে। ওটাই কিন্তু। My lord has got section 105.
So according to you, only the provisions related to compensation and other things shall apply.
Applies. So whether the question is very simple, my lord, whether section 93 can be resorted to. Because if it can be, then my title becomes clear.
Section 93 of the Metro Railways Act.
Now, of this act.
93.
It says completion of acquisition not compulsory. The appropriate government shall be at liberty to withdraw from acquisition of any land of which possession has not been taken. Because, my lord, under the 2013 Act, land vests only when possession has been taken. But in Metro Railways, it is.
Where is Metro Railways Act?
My lord, may I?
Section 10. sir, खुले दिए हमारे।
Metro Railways.
Miss Preeti Jain appeared before the competent authority and the appellate authority. Here we don't know, my lord. We are served. My lord, may I file the affidavit of service? My lord, see
Where is
section.
the vesting provision?
My lord, sees section 10, my lord.
Last.
এই তো এখানে।
10-4.
এই তো এখানে।
So on publication of section 10.
On publication of section 10,
it will
land vests. And my lord, under the 2013 Act, as it was under the earlier Act, my lord, 1894, the land was to vest only upon possession being taken, unless the temporary, urgent, emergency provisions were exercised and possession was taken before the award. Even then.
Similar to section 17 of the Act 1.
Act 1, yes, my lord. এটাতে কোথায় আছে রে? 2013 একটা প্রভিশনটা বলতো আমাকে। 105-106 তো আছে, কিন্তু না। And my lord, as it appears from section 93, possession once taken, land cannot be given back.
Here possession taken.
Here possession has not been taken, but the difference between the two acts.
So according to you, section 10 with vests.
Will vest. So whether, my lord, once the land has vested, section 9, can they resort to another statutory provision, which where the same statute provides that this will not apply. The statute will not apply to Metro Railways, the lands acquired under the Metro Railways Act. My lord has seen the fourth schedule. Item number 6 is the 6 and 13, my lord. Under Railways Act also, anything acquired under Railways Act or anything acquired under Metro Railways Construction of Works Act 1978, except the provision of compensation, nothing will apply. So our predicament is very simple, my lord. If they can, if my lord holds they can, my title becomes clear. Otherwise, my title continues to remain clouded for times to come. And the whole purpose is to avoid paying compensation. My lord, here the first notification under section 6 came in April 2017.
But unless the Metro Railways is here, how can this be?
My lord, fixes this matter, I shall give a, next date is 20, fixes it anytime next week, my lord. I shall give them another notice and,
What is this claim appeal and other things?
my lord,
appeal 102?
award was passed in our favor, about 40 crores. 52 crores. And then Metro filed an appeal. It is during this period of appeal when
What happened in the appeal?
it is pending, my lord. They have kept in pending. First, they filed an application under Section 30 to de-requisition the property, which was dismissed
So I
because,
can direct the disposal of the appeal. I think there you can raise all points.
my lord, once this notification is there, unless this
This notification was during the pendency
yes,
of the
my
appeal.
lord.
So you can take also this point in the appeal.
My lord, if I take this point that the competent authority is bound by this notification, the whole difficulty of it, the whole he cannot say decide whether this notification is constitutionally valid or not. The whole difficulty would be with on the basis of this notification,
There will be one difficulty.
the
One
claim will
is-
be allowed.
One is
Claim
this-
appeal will be allowed.
The appeal is pending.
Yes.
So if the appeal is dismissed, then what happens?
My lord, even irrespective of dismissal of the appeal,
So if the
this
appeal is-
notification, if it is to stand, will
If
stand.
the appeal is dismissed, so this notification goes.
No, no.
Why?
Because
The record is there.
then, my lord, they will approach the competent authority that we have come out of. Ye kindly recall your award. There will be multiplicity of. My lord, I am in.
The appeal after the appellate order, where is the question of the competent authority go beyond that order in the appeal?
If the circumstances change, my lord, this notification.
That is why I allow you to bring on record the subsequent event. That can be decided.
That they have brought it on record.
In the appeal.
In the appeal, they have filed a order
So I'm directing the appeal to be
But
disposed of, leaving
the
all points
competent authority, who is a statutory body, will not be in a position in all due
But why are
to
you
decide
saying
the.
many in all statutes, the authorities under that statute
My lord, I am
have been
question.
vested with the
My lord, I am question.
power to decide those.
My lord, may I pray this? My lord will allow the metro authorities to come, because veracity of this has to be decided.
The appeal is pending. For no useful purpose.
He will show. They will show this and get out of.
The appeal is pending.
They will show this and get out of the appeal. Succeed in the appeal on the basis, on the strength of this, my lord, because we are not taking the property. What is the? Why should the award remain? That is what is going to happen. That is why this has been done. Because first step was under 30 of the 1978 Act. That was dismissed because we submitted that you cannot take recourse to Section 30 because the project is not finished.
The petition
Lord, an unusual prayer. In the previous matter, 93, I am appearing on behalf of the petitioner.
Did not appear, Mr. Bhattacharya.
Milord, no, Milord, kindly excuse me, Milord.
All right, call 93.
I,
Who is for the petitioner? Who is for the respondent? Anyone appeared for the respondent? देखो तो 93
Somebody appeared for the respondent, my lord.
Who appeared? আছে রেকর্ড আছে 93 তে না নামটা আছে রেকর্ডটা আছে নাম
একটু যদি
who appeared for the respondent?
I'm-
Please
I'm-
bring him because
yes.
it was 93 টা একটু মার্ক করে রাখুন
may I
Please bring him. I will take when he will be coming. 95, yes. Yes.
95.
Yes.
95, my lord, I am for the private respondent. The last occasion, my lord, wanted from, my lord, to know from the petitioner, my lord, whether the read petition is maintainable or not, my lord. My lord,
You are for the
I am for the private respondent. my lord.
no. Your name appears for the petitioner, Mr. Ganguly.
Which one, my lord?
You are for the petitioner, not the private
Oh,
respondent.
I don't know. Oh, sorry. Oh, I was thinking about another matter.
So you are getting your writ petition dismissed for default, Mr. Ganguly.
My lord, here, my lord, what has happened, my lord? The my lord has heard this matter earlier also.
They
Yes. Overlap হয়ে গেছে আরেকটা আছে। My lord, there was, my lord wanted to have one instruction from the government leader. my lord.
yes. No. On your prayer, it was adjourned.
Yes.
It primarily appears that only a portion was the subject matter and not the entirety.
My lord. Now, my lord, I wanted to show that at the initial stage of
No, what was the portion which was reached out? 212 or 271?
212.
Then there is no dispute, Mr. Ganguly.
But the, my lord, physical position which I was granted, my lord, that was much lesser. My lord, that is why the
Please
entire,
kindly come to your prayer.
yes, prayer, my lord.
Prayer, please. Either to deliver the entire leasehold property
Yes.
or reduce. So your allegation was that the property leased out was 271. I was given possession of 212.
Mal.
But that's not the fact. Lease period was 200. The lease, the area was 212, and you were given 212. So there is no dispute.
But the area which I was allotted, my lord, that was much lesser.
What much lesser? How much you were allotted?
Yes,
that
my
was
lord,
not
kindly
stated. Mr. Ganguly, the water body was according to you 271.
My lord, the
So
water,
according to you, your prayer in the representation, writ petition was that the entire 271 was leased out, you are giving possession of 212. But from the lease deed, it appears 212 was the subject matter. So you are given the entire possession. That is why I adjourn this matter to take instructions.
my lord, in my prayer, my lord, I have stated, my lord, I have directing the
Please
respondent.
show me your representation.
My lord, at page to 98.
Please kindly come to 98. Please place 98.
Yes. প্রাইমারি পিসার্স কোঅপারেটিভ সোসাইটি লিমিটেডের পক্ষ থেকে বিনীত আবেদন এই যে বিগত সাচ তারিখে মুর্শিদাবাদ জেলার কিছু সরকারি মিনাদার বন্দোবস্তের জন্য আপনার অফিস থেকে নিলামের বিজ্ঞপ্তি দেওয়া হয়েছিল। বিজ্ঞপ্তি নাম্বার সাচ এই সুবাদে অত্র জেলার ডোমকল মহকুমার জলঙ্গি রিভার কুপিলা হইতে চর ফাজিলনগর জলঙ্গি তৃতীয় অংশ বাদে রিভাইনিং নামক 271 একর বিলটি ই অকশনের মাধ্যমে বাৎসরিক সাচ টাকার বিনিময়ে আমাদের সমিতিকে লিজ দেওয়া হয়। প্রথম বছরের খাজনা বাবদ এত টাকা অফিস হইতে এত জমা দিই, দ্বিতীয় বছর টাকা জমা দিতে চাইছি, কিন্তু দুঃখের বিষয় পরিবর্তন সময় ওই বিলের 271 একরের মধ্যে 212 একরের জায়গায় একটা লিজ ডিড আমাদের সমিতিকে দেওয়া হয়, বাকি 5962 একর জায়গা আমাদের সমিতিকে বুঝিয়ে দেওয়া হয়নি।
Yes. So in the representation, your claim was that the water body measures 271.70. You are given only 212.08. Now kindly come to the lease deed. Lease deed was for 212 and you have got possession of 212. So there is no wrong, no illegality. You are accepting that position. You cannot get more than what was leased out. Please see page 37, paragraph 2. $212. So nothing remains, Mr. Ganguly.
But my lord, here, as per my representation, my lord,
Representation is wrong, but the lease deed, the document will speak for itself. You are claiming more area than what was leased out. How that can be? The measurement is 212, not 271.
then how come 271 comes, my lord?
Yes. Anything more, Mr. Ganguly?
The instruction I could not get, my lord.
Instruction, no instruction necessary. Because the document speaks for itself. Ashun, the petitioner. Yes. Didi. There's one fixed matter.
Well, I'm on behalf of the petitioner.
Yes.
Well, I have ascertained from the records that the handwritten portion is there, my lord, in the written objection.
Lord, the written objection and the certified copy.
You give the certified copy, I think that's
Lord, since my lord, it was my lord supposed to be handed over to my lord's officers on that day. Lord, but in the process of delivering it to the other side, my lord, possibly got delayed. Kindly keep both, my lord, because there an issue has cropped up.
issue has cropped up. What issue?
My lord, an issue has cropped up with regard to my lord, this being court's record. my
That
lord.
when you submitted the copy you submitted, that is not the correct copy.
Yes. No.
Because prima facie, when the copy was handed over,
My
I
lord.
checked something for which it could not have been said to be subsequently incorporated. But since you are so sure that it was subsequently incorporated, I asked you to check up.
Lord, Mr. Chatterjee, my lord, was sure about it, my lord, that the handwritten portion is
No, it was just
missing.
Subject to
So,
correction.
my lord, it was
just-
my duty, my lord, to clear my conscience, my lord, first.
Yes, yes.
Paragraph 8, the last line.
Yes, yes, I've seen paragraph 8 last and paragraph 5 also last was not acted upon.
My lord.
Ashun. I'm not recording anything. I'm only taking this on record.
Yes, yes, kindly.
The copy of the written objection against the application under section 5 and 8 of the Arbitration Act and the certified copy and a duly certified copy thereof. The language of section 8, Mr. Let me use that. And a duly certified copy thereof has filed by Mr. Chaturvedi, learned senior advocate for the opposite party, is taken on record. First up, the petitioner is represented by its learned advocate. First up, hearing stands concluded. Judgment stands reserved. What's the next date, Mr. Chaturvedi, in the
That's sometimes in March, my lord.
March, my lord. My lord, I'll just check it.
My lord has stayed the further proceedings until the end of February or until, if not, judgment is passed. And going by, my lord, nothing waits. My lord delivers judgments very fast, so no difficulty.
Yes.
I'm grateful to my lord.
Thank you.
Thank you too.
Yes, ma'am. No, no, I am for the petition. In the last occasion, my lord, it was the reason of your lordships to direct the writ petition.
What is it you have for the petitioner?
Petition.
Yes.
আপনার 93 বরুণ মন্ডল তো না এটা তো সুভাষিস মন্ডল সুভাষ
বরুণ মন্ডল
আপনার 93 sorry yes
Sorry, no,
it's not my lord. It was submitted on behalf of the state, my lord. The plot of land has been acquisition, my lord, but they have shown the process of the acquisition, my lord. But because the reserve your lordship on the last occasion to direct them to produce a record regard to the payment of compensation, my lord. That on the last record, my lord, they could not provide. Initially, when the notification was published, the
yes, what is your instruction with regard to payment of compensation?
Payment of we have submitted a report, my lord. That is submitted.
From the report, it states Report does not say anything about payment of compensation.
Report was filed on the first date.
Yes, yes. I directed you to take instructions because I have recorded that it is silent as to whether the compensation amount was offered and paid to the predecessor interest. Whose
This
name
is a
was
land acquisition case of 1960 to 63, my lord.
Yes.
Because the papers, some time is required, where they are not, my lord, able to, my lord, trace the, my lord, record. That is the problem, my lord. But it has been stated in the report in paragraph number 3 that the land has been acquired under LA case number 44 Act 2 of 1960 to 63.
Yes, sir. Award was passed. Your name appeared as in the list of awardees.
Yes, my lord.
So
My lord, I have experience, my lord, in some other matter, my lord, similar matter, my lord.
yes.
The state has come up and said that the compensation was not paid, and
Here award has been
in that case,
declared.
in that case also, my lord,
This is an acquisition proceedings of which year?
1960 to 63.
but initial notification, my plot was not there. My subsequent notification was there.
When the award was passed?
But no, they have stated
Award was passed when?
1957 as per their record.
1957.
Yes, my lord.
So you were not even born at that point of time.
Yes.
So how could you say that the compensation was not paid?
Well, the documents they have.
Please, you have to show that on affidavit that neither of your predecessors nor you have received. Please take the responsibility of stating that on oath.
The land was,
sir, land was acquired, award passed.
Yes,
Your name also appears, your predecessor's name appears in the list of awardees.
yes, yes.
Now, after a long time, we were sleeping, now you are coming up. Please, after this, file an affidavit,
Yes,
take
ma'am.
the responsibility of stating that you
Yes,
have not
ma'am.
received.
Absolutely, ma'am. My lord,
Please state
what-
that.
since the physical possession of the land was not taken, my lord.
All right, please state that.
Yes, yes.
Please state
Yes,
all
yes.
these facts by way of an affidavit.
Yes,
Then after that, if I find
Yes,
you have received the compensation, then the consequences, you know, the filing of false
Yes,
affidavits, that will come.
my lord.
After 100 years, you will come and say, yes, my predecessors did not receive. You have to take some responsibility by filing, stating that on oath.
Obviously.
Because you were not born even at that point of time.
The land belonged to the grandmother of the petitioner.
Yes, you are not
Plot
born.
number
How do you
133.
know? How can you say that he has not received? What is the basis of that?
Since the physical possession was never taken prior to the
It's
construction.
neither here nor there. Who can say when the physical possession, when it will be taken? Who can say the physical possession was not taken?
The documents annexed in the report, my lord, not a single documents is there, my lord, with regard to payment. Only the entitlement,
You have to state first. Then I will call upon them.
my lord.
The petitioner states that paragraph 9, what have you stated? However, upon paragraph 9,
Both, my lord, I'm sorry, my lord. Both 5 and 9 does not.
5 and 6, my lord. 5, 6.
5 and 9, two statements is submission. How can it be your submission? What's the basis of your knowledge?
But the knowledge is, my lord, only comes to page 17.
No, how did you come to know? This is a fact prior to your death.
I have asked for information from the LA office, my lord. LA, the office of the.
Cannot be your knowledge. Show me that what the LA office has said.
The no acquisition has been took place. Page
What?
17. Page 17. it appears from the award of so and so. So I not acquired, the plots are not acquired.
That is in respect to another LA case.
Oh, another LA case, that is 43. Your acquisition is 44. What are you saying? You have made false statement on oath. Document shows otherwise.
Both the lands are
My lord, 5 and 6, my lord. 6 also.
Your positive query was whether it was acquired under 43. They have replied not on 43. An acquisition was at 44. Please take the responsibility of
Yes.
filing a positive
my lord, kindly,
statement on oath.
yes,
Then
sir.
I will consider
My
this.
lord, kindly allow me
To what?
to file a fresh, my lord.
What afresh? No afresh.
Or supplementary affidavit, my lord, kindly.
I will not allow you to withdraw this writ petition.
Then my lord, kindly allow me to.
I can dismiss it if you want, not with liberty. Not with liberty.
But in that, you know, kindly allow me to use a supplementary affidavit, my lord, with instruction from my client. That's all.
Yes, who is for the state? You are for the state.
You are almost identical in the matter, my lord, which your lordship passed in item number 4 in
Yes.
the morning. Now, my lord, I was granted a long-term mining leave. My lord, this my lord will be pleased to find.
But the corporation is not here.
Go.
So what is the corporation?
Yeah, then my lord, would you, my lord, it will not take even more than 5 minutes time of my lord. So it be my lord's pleasure, my lord, to take, because after 2, your lordship is taking up cooperative matter.
Yes, where is Mr. Shah?
That's a reason, my lord,
Can you bring Mr. Shah at 2 p.m.? Mr. Banerjee, Mr. Bandyopadhyay, can you come at 2 p.m.?
But my one matter is going wrong.
Your junior will be here.
He will be there.
He wants consideration of his representation, which is a similar order has been passed
Yes, in
in
the
the
morning.
morning.
Yes.
Uh,
Now I just only.
Also for 2 years. This lease is also for 2 years.
Lease, kindly take this lease. There is a mention of 5 years. Kindly see at page 10, third line.
No, but in the lease deed, in that, all right, I'm not going to that 2 or 5. Oh, here you have annexed the lease deed. 5 years, yes.
And your lordship may kindly pass an order to the effect that will not having regard to the having and 5 years Joseph Sunitha. Having regard to the representation which has been filed at page 14 and the observations which my lords have given, that in view of the particular Milord
Ask Mr. Saha to come. Mr. Bandyopadhyay, in the earlier matter, I have directed the ATM to take a decision on the representation of 2012. And if the prayer cannot be allowed, then the reasons therefore are to be commented. And if the petitioner has to take further steps, that should be indicated in their report also. Because in the meantime, 2002 Act has been repealed, 2016 Act, now new policy. Mr. Shah was saying that auction for empanelment and other things. If that is so, that is to be indicated, you will take that steps.
May I only submit one thing, because I am facing a very important Milord, a particular pressure from all members of the bar. Bar Association of West Bengal has been issued a contempt rule in
Bar Association or Bar Council?
Bar Council of West Bengal. I stand wrong. Milord has been issued a criminal contempt before the court of my lord Mr. Justice Devanshu Bosak. Now, my lord, I have to appear on behalf. Kindly take it at 3. If it suits my lord.
Cooperative matter starts, then
That's the thing, my lord. If it is only a mutual thing, my lord.
there's the one thing, it has been indicated that after the cooperative matters, if time permits, this matter will be taken up.
But my lord, in the event it is not taken up, my lord,
Come at 4:15, bring the other side in case it is not taken up prior to that.
Lordship, one matter has been assigned for a bench of with your good lordship and another bench. So when that matter will be taken up, that
Please hand over the slip.
say review 200.
Mr.
Review
Banerjee,
200 2023.
Please hand over the slip.
I'll do that.
Mr. Banerjee is
Thank you.
also saying he has no, my lord, difficulty in respect of the order.
But Mr. Saha is there. Now
Yes,
the corporation is the only effect.
Grateful.
Corporation
Under compelling circumstances, also have come before your lordship.
Yes.
That 11th lordship, tomorrow is the date of opening the financial bid of a ferry ghat. Now lordship, 6th they have rejected my application. 7th and 8th was the holiday. Lordship, the 9th I have got this order and immediately filed objection. Today, Lordship, I prepared the writ petition. So I
will appear tomorrow.
Lordship, I am praying for leave to move this matter tomorrow, Lordship. Kindly
File it.
also serve the copy to the landed government pleader
Serve
because
the copies. Yes.
ferry ghat is the ADM, LRO is the authority, Lordship.
Please serve the copy.
Well, in the matter of 93,
yes,
Mr. Bhattaji has gone to another court, one specific. সাথে বলেছেন আপনি তো আছেন
94 আছি
oh 93 Malad, your lordship already passed an order and taken it.
Please let me. I have told him after the cooperative matters I will take up.
Oh,
yes. If not, please come at 4:15. Yes.
My lord, in item number 94, I am appearing for Metro Railway. An order has been passed. I was appearing in court number 1. My lord,
nobody is here.
Senior Advocate Joyantomitra sir is also here. He was also in court number 37. My lord, we could not come. Kindly adjourn the matter.
But I have passed an order in the presence of the other side. Please inform them. Otherwise,
my lord, I will inform them, my lord.
Call them, bring them, then.
My lord.
Yes.
Item number 129.
Lord, I am for the state respondent. I have for the register.
This is my affidavit of service.
Yes.
I'll in short manner, the husband of the petitioner initially joined as lower division clerk. Thereafter, he was placed under suspension in 1978. Now, what had happened? There was a delay in departmental proceeding. I had to initiate a writ petition before this court. In 1984, my lord kindly comes to page 20. The order passed by this honorable court in that writ petition.
Page 20.
Page 20, my lord.
Yes.
Yes, my lord. Page 20, my lord will find from the second paragraph. After the above order is passed, may I read, my lord?
Yes.
After the above order is passed, with the consent of the parties, the matter is treated on his day's list and taken up for hearing and disposed of accordingly. It is in this case, petitioner was suspended in contemplation of domestic inquiry on 15th of July 1978. Mr. Yamin Ali contends that the petitioner is still in suspension and the disciplinary proceeding is not over yet. Having regard to such submission, the writ petition is disposed of by directing the respondent authority to conclude the disciplinary proceeding within a period of 6 months.
What happened in the disciplinary proceeding?
Nothing. They have not concluded it. By the time I retired by superannuation, I died. Even before my death, they could not conclude it. Now, subsequently, my lord, they published a memo, which is at page number 28.
Yes.
This is the memorandum, my lord, acknowledging that I have been superannuated and I have deceased. My lord, kindly comes to page 29. That is the order passed in that memo. Therefore, in compliance of the direction of Corporation Department under its memo number such and such, the period of service of Milan Kumar Tarafdar, ex-lower division clerk of the Corporation Directorate under suspension from such and such to the date of his retirement, 29th of February 2004, is treated as duty for all purposes as a disciplinary proceeding against the...
Yes. So order is in your favor?
Order is in my favor.
Yes.
Not the execution thereof. That much.
You are the authority.
No, I am appearing for the principal accountant general, who is not a necessary part.
Who is the authority?
Well, the order was passed by the Register of Cooperative Societies.
Yes, but the cooperative, who has to pay this amount?
Register of Cooperative Societies is respondent number 2. Accountant general will, by virtue of the order of the respondent number 2, respondent number 5 will release the money.
Who is appearing for the respondent number 5?
My lord, this is
Respondent number.
This is group service matter, my lord. He was an employee of the state government in Corporation Department.
Yes.
So, my lord, I think group 5 though. No.
All matters relating to cooperative societies. Was an employee of the cooperative society. Cannot be group 6.
My lord, so for the prayer of the...
After all, he is an employee. You have passed an order in his favor.
My lord.
So why are you not releasing the benefits?
No, my lord, it was admitted by them that in 2011, my lord,
yes,
Directorate reinstated the period of service of so and so.
Have you paid the amount, the benefits?
My lord, that benefit has been given, my lord. That benefit has been given.
Which benefit?
My lord, so far, this is a matter of, my lord, if your lordship kindly see that they have filed this writ petition, my lord, after so many years.
Cooperation director. Cooperation department. Not cooperation.
And I can explain the delay. There was a contempt proceeding which
My
was
lord.
pending till 2021.
Area page.
My lord, kindly see paragraph 4, my lord.
Paragraph 4 of?
4 of the petition, my lord.
Yes.
That is a lower division clerk in the Corporation Directorate, Government of West Bengal.
Yes.
So that's why he is not a employee of a cooperative society.
Employee of the Cooperation Directorate.
Directorate under the
Yes.
state
So he
under
is
the
a
state
government employee.
cooperation department. What my learned senior friend is saying, he is under the cooperation department, not a cooperative society.
Not a major party.
So it is a state. So
Yes.
SAT will state administrative tribunal is the appropriate remedy.
I have a reserve.
That is
Just
before that.
Shogutta Bhattacharya, no. But there, since the SAT is not
That is not functioning.
Yes, my lord, it's lying
single bench
vacant.
will see at the matter. Yes.
Lying vacant, my lord. And this order
Yes,
passed
that
by
SAT
is over now.
functioning.
even
Then
this
also it will go to group 6.
my lord, this order was passed by the division bench. It
Yes,
was
sir.
taken.
Taking this plea of this group 5.
Lord,
Group
I am to assist your lordship. I have nothing
I
to.
can please move group 6 bench.
They are not groups.
Because you are not a cooperative society.
And yes, my lord. Kindly
Because they are taking this objection.
with regard to the objection of the SAT not being there, my lord, kindly
That
clarifies that
by
much.
group 6.
Clarifies that much.
That they have not pleaded, my lord.
Yes, my lord, I have the order because
Go before that bench.
Very well.
That bench passed this order. I
Same.
don't think you will be in difficulty. Also.
The
The learned advocate
grateful, my lord. The affidavit of service.
No, disposed of.
My lord, the affidavit of service was handed over.
The service
Taken on record, my lord.
taken on record. Yes.
I'm grateful, my lord.
130 Milord, I am for the petition.
Item number 130 Milord. I have been instructed over telephone to appear in this matter on behalf of respondent number 1 and 5 Milord. Milord, I do not have the Vakalatnama right now, Milord.
Yes, what is this matter?
This matter, what happened, the respondent of the issued a notice inviting the tender for construction of turmeric boiling and processing unit. In terms of the said notice of tender, the petitioner participated in the tender process and ultimately petitioner succeeded.
What is the present grievance?
Given non-payment of admissible dues, the petitioner made representation that is at page 63. That has not yet been disposed of by the.
Page 63.
Yes, by the respondent authority.
Yes.
Milord, may I take instruction and come back? Milord?
Dispose of this representation. He has made a representation, pass up reasoned order on this. The petitioner.
Your Lordship, the registrar has not been made a party, but what I think is, Your Lordship, this matter is a private dispute between the cooperative society and a person who has done some work. Possibly this society is also agreeing now when Your Lordship is passing this order. We have seen such cases where there has been a collusive order between the petitioner and the society. By taking the dint of that order, certain funds of the society has been siphoned. I will just be pointing out, Your Lordship, to see that these cases are not taken up in this fashion because they have purposely not made the registrar a party, and this is admissible dues. They are accepting admissible dues. Now with Your Lordship's order or for consideration, they may pay off the money, and later it will be seen that the work which he is claiming to have been done might not have been done. So these things,
You can take steps in accordance with law.
Your Lordship, the registrar has not been made a party, and if Your Lordship passes an order, what happens is if there is a dispute of recovery of money, then the matter should go before 102 before the registrar. So the registrar takes evidences whether the work has been done, whether the bills are legally submitted or not. Thereafter, the money is disbursed. However, what they have done is
Section
102, Your Lordship. Kindly see section 102. Arbitrator. This registrar as arbitrator. Yes. Section 4 subsection 25. Kindly sees the definition of dispute. Section 4 subsection 25 defines the dispute.
Yes, sir. What do you say?
I have made the state party. ARCS also.
This is a dispute which is to be resolved before the registrar.
I have
I'm
made-
directing, I'm giving you liberty to make a representation before the
I have
registrar.
made a copy of
They
the
have-
same was served upon the
Copy,
This is
copy
not
of the same was served.
Yes, my lord.
Your
That's-
Lordship, the representation will not do. There is a rule, specific rule of filing of plaint.
Please accept that representation, again a rule.
Your Lordship, kindly sees. What happens is,
Yes.
if the representation is considered and any order is passed, it will be in the basis of summary manner, which may not give fruitful result, and they may come up with the challenging that order.
Yes.
However, if a dispute case is addressed in section as per section 102, there is a cooperative tribunal where that award, if he is at all aggrieved, can be appealed to. Kindly sees the manner in which the dispute has to be filed. 167. Rule
Alright,
167.
so I give you liberty to approach, to file a.
In terms of section 102.
There's a dispute in accordance with law, and I will direct if you approach that authority, I will direct the registrar.
We will
to-
decide it as
I think both
expeditiously.
the parties will be there. It will be.
Your Lordship.
I have made representation and copy forwarded to the ARCS.
So, but you have heard him because unless
And
that
this is
done,
Rule
they may
167.
say yes, it's not in prescribed format. I am disposing of by giving. So you apply in the prescribed format.
Rule 167 is the procedure.
না প্রথমটা তো
Specify the time for making application.
That's up to you. You can take 1 week,
Otherwise-
you can take 1 day, you can take 2
Your
months.
Lordship, then kindly 12 weeks from the date of
12
filing.
weeks
of-
from the
From
date
12 weeks
of
from the
receiving
date of filing of such, I've said,
Receiving.
from the date of. Yes. from the date
So
of
sorry.
filing.
affidavit of service.
The time, filing time is with you.
But the disposal time within 12.
Yes, from the date of filing of the case.
My lord,
Yes,
my lord, in item number 94, my other side has come.
yes, she has appeared. Mr. Mitro is ready in this matter.
My lord, kindly fix it next week.
And it is already fixed it on 17th.
My lord, kindly adjourn it. My lord, kindly adjourn it because I could not appear and it has
All
been
right, I'm recording your presence. What was the item number?
94.
94 and a Yes, who is appearing?
My lord, petitioner is a small fisherman taking loan from the Balagaria Central Cooperative Bank for fishing business. Thereafter, due to heavy flood, the loan account was defaulted and bank proceed for proclamation of sale. In the time of sending the affix the sale notice, bank only gave a 7 days date, which is minimum a sale notice period is 30 days under Rule 191 of the Cooperative Act Rules 2011. So they only give a 7 days notice affix in the dwelling house of the fisherman. Kindly give a interim relief and
What is the amount due from him? You.
He took 25 lakhs of rupees as over OT.
How soon you will pay that amount?
they pay by installments.
Approach them. for
I
installment.
already
My lord, he can also approach the sale officer.
yes, I already write a letter.
Liberty to approach the sale officer to liquidate the amount in installments. If that is done, that will be considered by.
So grant some relief, interim relief, my lord, because they
When is the
affix
sale?
the sale notice and sale date is within
You
7
approach
days.
them, when is the sale going to happen?
Sale is 29th January.
Over.
Over.
So
Before that, I filed the writ petition.
they're
No,
conducted.
My lord, conducted, but there is no bidder, my lord. That is why it has been deferred, my lord.
To approach them for how soon you will pay or file an affidavit stating that you will pay installment.
In every sale notice, my lord, they put a earlier date and notice served.
No,
Right, you want to dispose of the pay off the amount. Please tell
Even,
when you
even,
will
up,
be paying off
even
the
after
So,
sale,
my
my
lord,
lord,
Now,
kindly.
your challenge is with regard to the sale notice.
Yes.
So now the sale
Now
notice.
also sale notice, also 191 mandatory representation.
So now the sale has been conducted. Now they said that they have no bidder, so they will take fair steps. So this become infructuous.
and even if, my lord, the sale is, my
My
lord,
lord, then kindly other alternative efficacious remedy file before the register grant a leave.
Register for
We will
what?
file the register of
For what?
cooperative. For there is a discrepancy, they not supplied
But
any
there is no
bank
discrepancy,
statement
nothing, my lord.
and
This has become infructuous now. Writ petition sale has already been conducted. So
My
what
lord,
remains in this?
date has been deferred.
now they issued a fresh sale notice
When
after filing the writ petition.
next steps, you have not
That
challenged
notice is alive now.
challenge that.
My lord, kindly see
Kindly give
section
a
122, my lord.
That liberty is
My lord,
not
kindly
restricted.
see section 122, my lord. Kindly see at once.
122.
Two, my lord.
Section 122.
Yes, my lord.
Yes.
Not restricting anything contained in any other law for the time being in force, where a power of the sale or delivery of possession in respect of the property sold without the intervention of any court is expressly conferred on a cooperative agriculture and rural development and such as cooperative or private society, financial bank or private agricultural society by a mortgage deed in favor of the bank or the society as the case may be, if any installment under such mortgage is not paid in full on the date on which the falls due, if the board of directors of the bank or the society as the case may be shall, in addition to any other remedy available to it, have the power, subject to provisions of this act, the rules, and to bring the mortgage property to sale and deliver the possession of the property sold to the purchaser without intervention of any court.
Yes.
My lord,
What does it mean?
my lord, without intervention of the court, but the proceedings already started, my lord.
Yes.
My
So
lord, he has
court
not
cannot
paid. My lord,
interfere.
kindly see. My lord,
This is the
kindly.
interpretation of this section.
My lord, kindly see
What
page.
are you saying?
My lord, kindly see page. Page number.
If you want to give that interpretation, then right now it will be declared ultra virus. That's not the interpretation which you are giving. It says you may not approach the court for intervention, for giving power to sell, and that's the interpretation.
Yes.
It's not the interpretation that once
Court
said
has not-
proceedings are started, court cannot interfere. It's not that
My lord,
interpretation.
this is provisions of law, my lord. My lord, kindly see the 90 days notice has already been given, my lord. My lord, kindly see.
If he is aggrieved, he can challenge that. This sale notice has.
He can approach the bank, either the bank or the sale officer. And his
The
prayer in
Yes, next. 132, yes. Yes.
Your Lordship, in this matter, I was directed to file a report in the form of affidavit. I have got
What is
hold.
this issue? What is the matter involved?
One operator Giri took loan from the bank. She did never pay. A case was filed under section 139.
Reduction of an amount from your retirement benefit.
Yes, but the question is the 8 years back, certificate officer passed an order for attachment of salary, and there it has stopped. The block medical officer of health is not doing anything. And I don't know why the certificate officer is also powerless before him, because nothing has been done. So some direction has to be given.
Direction was given to me, Your Lordship, to file a report in the form of affidavit.
Yes, you have not filed that.
I have got hold of the documents, but the entire facts is not
How
before
much
me.
time you want?
2 weeks, Your Lordship. 2 more weeks.
The honorary advocate appearing for Yes. Yes.
Lord, the last occasion,
On the last occasion, Lordships in the order sheet, Lordship, I think, has failed to take note of one judgment cited by here. 2022 was not put on record, Lordship.
এটা কি অন্য ফাইল দিলেন নাকি?
and thereafter, my lord, I am coming to the judgment.
Of which writ petition?
First writ petition,
682.
682. More specifically, my lord, the paragraph, page 4. My lord, the aforesaid notice inviting tender were published without making any provision for the cooperative societies under the government of West Bengal, inasmuch as those are contrary to the purchase policy of the government of West Bengal. This is the contention of the writ petition. And my lord, nextly, my lord, so far the scheme, my lord, I am not seeking scheme outside the provision of the statute. My lord, statute speaks that, Lord, kindly come to the West Bengal Cooperative Society Rules 2011.
Yeah. Yes.
Grant of preference exemption by this
rule. Which rule?
My lord, 96.
96. Yes. Yes.
Grant of preference and exemption of the by the state government under subsection 3 of section 60 in respect of any cooperative societies or class of cooperative society in the interest of promotion of cooperative movement in the state government may by general or special order grant preference, Roman 1, preference in the matter of settlement of land and fisheries owned by the state government. Roman 2, preference in the matter of making.
So according to you, a mandama should be issued directing the government in terms of Rule 96.
In terms of Rule 96, Mullah.
So an order, a general or special order has to be passed in
My lord,
respect
there
of
is
these clauses.
There is also a special order, my lord. Purchase policy has been given, my lord, and on the basis of that, my lord, Rule 47 of the West Bengal financial rules has already been amended, and there has already made certain provision for the cooperative society. So, my lord, my mandamus for directing the particular state government to forming the scheme not outside the purview of the statutory enforcement. This is my first submission. Secondly, my lord, I am coming to the judgment, my lord, that 22 judgment on the basis of the, my lord, that is, my lord, the one civil service examinee was appearing, my lord. She has already, তাই তো যেটা তুমি দেখাতে চাইছিলে, the 22 judgment might be, my lord, the one civil service examinee was appearing and she had sought that the attempt to be liberated more than 3 times, which has been marked, which is the subject matter of the notification due to COVID reason. And my lord, secondly, this particular judgment, my lord, 2015 volume 2 SCC page 796. My lord, the discussion.
Mr. Gali, we have given copies of those judgments.
I have given copy of those two judgments. So far as 2020, those are, my lord, recorded.
Yes, 2015, volume 2, yes.
And another one is unreported coordinate bench judgment of our honorable court.
This is a division bench judgment, my lord.
Division bench judgment, Oshesh.
Yes, yes.
And I've given reference to my learned friend also for the petitioner.
Yes, yes.
And the other one is 2022-11. It's the very longest judgment.
Given a copy, no. You have
Very
not given a
longest judgment. I have, my lord, placed the
State cannot give a photocopy of a longest judgment, Mr.
lordship.
Gali.
No. This is, I do it on my own, my lord, from my SSA online.
No, my lord, which I have referred, that is not that judge.
I think you are referring to this 15-2 over there. 15-2 SSA 7.
15 না আরেকটা যেটা 22 যেটা তুমি বলছিলে
না আমি করিনি, আমি দুটোই করেছি আর এটা।
I'm coming to the 15-2, my lord. Stately, my lord, coming to the paragraph 23 of this 8th judgment. The centripetal, my lord, got it? Paragraph 23.
Yes.
The centripetal question that emanates for consideration is whether the High Court could have issued such a mandam as commanding the appellant to carry out a census in a particular manner. The High Court has, and my lord, then thereafter, my lord, the judicial principles were discussed, and their lordship considered this is a 3-bench judgment, my lord, division bench judgment, considered that this scheme cannot be, my lord, here, my lord. Then 34. As has been stated earlier, central government has issued paragraph 34.
Yes.
33, my lord, first I am coming to the 33, then 34.
Yes.
From the aforesaid pronouncement of law, it is clear as noonday that it is not within the domain of the court to embark upon inquiry as to whether the particular policy is wise, acceptable, or whether a better policy could be evolved. The court can only interfere if the policy framed in absolute capricious or not informed by reason or totally arbitrary and founded ipse dixit offending the basic requirement of Article 14 of the Constitution. In certain matters, as often said, there can be opinions, but the court is not expected to sit as an appellate authority of an opinion. This is the, my lord, the epitome of this particular judgment passed by their lordship.
Yes.
Now, my lord, I am citing your lordship a much older judgment. Azad Rickshaw Puller Union, Town Hall Amritsar and others versus State of Punjab and another. This is, my lord, 1980 supplementary Supreme Court cases 601. This is also a 3-bench judgment, my lord.
1980
Supplementary Supreme Court cases.
SCC page.
SCC 601.
3.
3.
1980 supplementary Supreme 3.
The challenges in this repetition compels us to remind ourselves that under our constitutional system, court are haven of refuge for the toiler, not the exploiter, for the weaker claimant of social justice, not the stronger pretender who seeks to sustain the status quo ante by judicial writ in the name of fundamental rights. No higher duty or more solemn responsibility rests upon this court than to uphold every state measure that translate into living law preambular promise of social justice reiterated in Article 38 of the Constitution. We might have been called upon to examine from the angle of the constitutional humanism the virus of Punjab Cycle Rickshaw Regulation License Act 1976, Punjab Act 41 of 1976, Act for short, designed to deliver the tragic tribe of rickshaw puller whose lots is sweat, toil, blood, and tears from the exploitative clutches of the rickshaw owners by a statutory.
For what proposition we are citing this judgment?
Milord, first of all, Milord, this here, Milord, for the rickshaw puller, the scheme was framed that the rickshaw puller will be given the finances without, Milord, giving the, that is, Milord, the guarantor. That scheme has been framed. So, my lord, my first condition is that within the purview of the statute, scheme can be framed. So, my lord,
There is no dispute on that.
Yes.
Within the provisions of a statute, the scheme can be framed.
Yes.
There is no.
And that is why, Milord,
regard to that.
from that is why, Milord, from the very at the outset, Milord, I have referred Rule 96 of the West Bengal Cooperative Society Rule 2011. Then, Milord, 2017 Volume 3, this is a two-bench judgment of the Honorable Apex Court
For what proposition?
for the, Milord, entitlement or non-entitlement scheme from providing better working condition. In the paragraph 3, Milord, Ruma Devi also discussed, Milord.
The different thing altogether. Please see the relief claimed in paragraph 1, prayer A, it has been quoted. They wanted extended the similar benefits as others.
Yes, an appropriate writ of mandamus.
This is not the issue here.
Milord, issue here is that, Milord, preliminary issue is that whether within the mandamus, Milord, the scheme can be framed or not. If there is a provision.
That's not the issue. Whether mandamus can be directed to frame a scheme in a particular manner. That's the issue.
Milord, I am seeking the enforcement of the Rule 96. And, Milord.
So, enforcement of a rule, for that, mandamus can be issued. Yes, please frame a scheme in the light of this. Please show me a decision on that point. That there's a rule and a scheme. Rule provides for framing a scheme. Scheme
Milord,
is not being.
the rule.
Scheme
Rule
is not.
provides, Milord, rule provides, Milord, there is a specific, Milord, sub-rules where there is a, Milord.
That is what I am saying.
Yes.
The rule provides for certain categories, sub-rules.
Sub-rules.
So the state is sitting tight, is not framing a scheme pursuant to this, is not passing a general or special order. Please show me under such circumstances a mandamus can be issued. Directing, please frame a scheme in this light of this. I want to know their judgment.
Milord, this is a rule, Milord, and this is a statute, Milord. Statute has a binding effect. So, Milord, mandamus could not be issued for. I am asking myself, Milord, mandamus could not be issued for.
That's also my question. Please give me something, because I have come across judgments in a different line. It says no, it's not your duty. It's the duty of the legislature.
And
that's the question which I have raised. That's a very, very well settled proposition of law. And even if it gives a discretion whether a mandamus can be issued directing, please exercise that discretion in this particular manner. Mandamus can be issued. Please show me decisions on that.
Milord, there is. I have already shown your lordship that there is a purchase policy, Milord, and purchase policy. There is a room made for the cooperative society.
That I followed. That you have argued. That I have followed.
And Milord, the particular notification didn't make any room for the cooperative society. This is point number one of my argument. Second is that, Milord, in other contexts, Milord, the engineering cooperative society, there is a reservation in the PWD for the cooperative societies of the engineers unemployed. And even, Milord, labor cooperatives are also there.
According to you, which provision of this rule is they are violating? Rule 96, which provision? Which clause?
I'm showing. I'm coming. Milord, Rule 2, preference in making matter of making purchase and fixing prices thereof.
That you have said that there is a purchase policy.
Yes.
So they have not violated this.
Milord, there is a 15%, Milord, price preference has been given in the purchase policy. That has not been given here, Milord.
Where? Which provision, which clause is violated? This preference in the matter of making purchase and fixing price, that there is a policy according to
preference in making the placing the contractor or government without inviting open tenders. So, Milord, Rule 2 and 3, and Milord, in the purchase policy, there is a particular, Milord, I am coming to the purchase policy once again, Milord, to refreshing.
What is the relief you have claimed in this writ petition?
Milord, framing of this scheme only, Milord.
You also know what you have prayed for.
And Milord, I'm showing your lordship, that is, Milord, first, Milord, page 175.
Anything more? Anything more? This is your prayer A.
Yes.
Prayer B also. The decisions are against you on this. You have not shown me any decision which says otherwise.
Milord, my contention is that, Milord, there is a, Milord, your lordship has already seen the 175, that is page 175 of my writ petition, and there is a provision made for the engineering cooperative societies.
Yes.
And Milord, thereafter, Milord, the purchase policy I have shown your lordship. And particularly, Milord, page 189 of the second volume, note 3A, where the government stationaries offices fail to supply stationaries article to the state government offices as per their intent, such article may be purchased from the cooperative societies without.
So according to you, the Department of Health and Family Welfare, this department has not given you preference.
Yes.
Only this department.
Only this Health and Family Welfare and, Milord, the ESI.
Which paragraph you have stated that ESI?
Milord, this ESI, this first writ petition for ESI.
First is for ESI.
ESI.
This
Second is for health and family welfare.
First is, no, 11154 is the second or first?
Second.
Second is for?
Second is for health and family welfare.
Which paragraph of the writ petition? Please show me that.
My lord, paragraph 6.
Paragraph 6 of
111154.
11154, paragraph 6.
It is required to be mentioned in this context that the petitioner already made representation. My lord, got it? Paragraph 6.
Yes.
Represent.
This is the health and family welfare.
Yes. Before the authorities praying inter alia for framing scheme of the cooperative societies in West Bengal participating contractual supply works in the hospital under the Department of Health and Family Welfare, such and such, and Milord and others in the hospitals run by the Department of Health and Family Welfare under the respondent number 2, 3, and 4.
Under the, this is health and family welfare.
This is the health, and it is
Yes.
necessary to
And
mention.
the other writ petition,
Other writ petition for the
which
Milord,
paragraph is for ESI? Please
yes,
show me.
that is Milord, paragraph 2 at page 4.
Paragraph 2, therefore said, you have not mentioned which department. ESI hospitals,
ESI hospitals, Milord, and this is the Milord, the Labor Department.
Department of Labor.
Department of Labor.
So according to you, this Department of Labor and this Department of Health and Family Welfare, they have not framed any particular scheme in terms of Rule 96.
In Rule 96, as well as there is a specific purchase policy issued by the government of West Bengal, being the respondent number 1. I am relying another judgment, my lord, J.K. Kaul and another versus State of Jammu and Kashmir, where a scheme was prepared following the statutory provisions made under the Jammu and Kashmir Migrant Immovable Property Preservation, Protection and Restraint Distress Sale Act 1997. This is, my lord, 2010, volume 1 SCC, page 371.
Give me a copy.
My lord, I don't have copy, my lord.
For what proposition?
This is, my lord, within the statute, my lord, scheme of the statute, my lord, the mandamus can be issued for framing of this scheme.
The 10-1 SCC page.
2010, volume 1 SCC, page 371.
Paragraph? Which paragraph?
My lord, I have only one copy, my lord.
দিয়ে দিলাম তো।
Where the direction where it was held that a mandamus can be issued? Please show me which paragraph.
Milord, this is here is Milord.
Show me the paragraph.
Scheme was framed, Milord.
Sir, that's a different thing altogether. Here, there, the High Court did not pass any order,
Yes.
directed the authorities to consider. So against that, they were aggrieved. They moved before the Honorable Supreme Court. In the Honorable Supreme Court, the Supreme Court asked whether it can be done. There, the state filed an affidavit saying that yes, we are going to frame a policy. So this is the policy which was given,
Yes.
and Supreme Court said, in view of the affidavit undertaken given by the state, we dispose of the appeal with a pious hope that the state will take all endeavors to rehabilitate the persons who have been a victim
So,
until
Milord,
such. So it's not a direction. Mandamus was not given. State volunteered when the matter was pending.
state has already
Let them volunteer. I am not against them, but no mandamus. Please show me that a mandamus was directed. So this is against the well settled. When you said the Supreme Court directed, I wanted to see that. Please show me which paragraph.
that is it, Milord. The state has come with a proposal.
If they come, I'm not against them. But
That
mandamus,
proposal is already there.
sir, it's not that, because the rule is there. Giving them, they
Purchase
can
policy is there.
frame rules in their own way, but mandamus cannot be issued. That's my query to you. Please show me something where a mandamus can be issued. There, the state volunteered, saying yes, we will do that. Filed an affidavit that they are framing a policy. Our Supreme Court accepted that with the expressing the pious hope and trust that they will do that. Mandamus was not issued.
In my context, Milord, there is
The state wants to frame, the state are
there
free
is
to.
already a purchase policy, Milord, where there is a provision was made for the cooperative society.
And this says may by general or special order grant. It's using the expression may. It gives them discretion. So when it gives them discretion, mandamus cannot be asked, directing them, no, please do it in this particular manner. This is against the settled principle. Ashun, the petition.
You kindly deal with that side.
This is on merits, I am not going
Yes,
to.
yes, my
This matter, your lordship dismissed.
my lord, only the question of
For supply of cooked, cooked diet food, comma, scavenging, washing, cleaning, supplying of different types of equipment, comma, surgical equipment, furniture, fixtures, etc. in the hospitals run by the Department of Labor under the government of West Bengal.
My lord, these NITs are pertaining only to the, my lord, cooked food, my lord.
Oh, this is only, but you paragraph 3 you have said
Yes,
শুধু তাহলে cooked food আর অন্য কিছু না।
yes.
Please take back the book because I have not relied upon. ওইটাকে কেটে দেবেন 2000
My lord, 132, I am for the Mugberia Cooperative Society.
এটা আমাদের বই না তার লাগবে আমাদের।
এটা তো 33, 34 হলো তো।
30 lordship.
না না এটা 133, 134 হচ্ছে।
This is 133 and 134.
Oh,
That will not, I when I check that.
132. Please give your appearance. Yes, call the next matter.
Get roots. Head number.
ওটা দিইনি বোধহয় 2022 হ্যাঁ ওটা রাজীব ওইটা না আমি আগে বলেছিলাম ওটা কেটে দিই they have referred to 2022 জাজমেন্টটা কেটে দিই
Golden.
yes
instruction কি পেয়েছে?
yes call the 135 who is appearing
কি বলে?
yes
Last time your lordship directed Mr. Mahathir to appear in this matter on behalf of the SI.
on behalf of the SI, yes Mr. Mahato.
Yes.
This is with regard to deduction from the
Section
return.
29.
Yes Mr. Mahato, what is your instruction?
My lord, may I say one thing, my lord?
তো আমাদেরই তো নাকি?
My lord, on behalf of Mr. Mahato, I am appearing in this matter with Mr. Mahato in these two matters. My lord, I have already talked with the sub-inspector of schools. The sub-inspector of schools of that Shodor circle told me that since it is a question of employer-employee and it is a DPSC Purbo Midnapur, who will be the actually answering authority?
Who will be the answering respondent?
DPSC Purbo Midnapur, that means District Primary School Council. And probably Mr. God is
So
appearing.
Mr. Misro, you are appearing.
Mr. Misro.
Mr. DPSC.
Yes.
Yes, what is your instruction? Yes. What steps have you taken?
It has been taken, lordship, the finance officer is an appropriate authority. He has not obtained no objection. That is why, lordship, the employer, lordship, the finance officer is an appropriate authority, and the chairman, when the loan was sanctioned by the society, no objection has been put. That is why I have taken appropriate step.
No, but now he is under your control. So
First an order, then I will take an appropriate.
why passing an order? Why an order is necessary? As per the law, you are entitled to take. What steps you will take?
I have not taken any steps to the law.
That you have said. What steps you will take?
কবে থেকে
Yes.
retirement?
Teacher under the control, council, lordship.
So, Mr. You have to take the responsibility. Please take steps. Please communicate your decision with regard to this. Where is your representation to the authorities?
Requisition is that.
That is not there.
No,
That is not there. The representation is addressed to the the headmaster.
33 lordship.
That is the requisition.
To the
Yes,
headmaster.
District Primary School Council.
Chairman
representation is
District Primary
there.
School Council is there.
Yes.
Yes.
Yes, yes, Mr. Misro. Yes, the chairman, district Yes, call the next matter.
136 is a similar matter, my lord.
Yes, same
Similar matter,
PPSC,
same order.
same order. Next,
136, Lordship.
same order.
Same order.
Yes, next, call the next matter.
137 and 138.
137, 138, yes.
My lord, I am appearing on behalf of the last occasion, your lordship was direct. My lord, and senior friend was appearing, my lord.
Yes, yes.
You have
137.
one writ petition. My lord, your lordship directed that.
Yes, my lord, I have got the report, my lord, that from this month, my lord, deduction is being made.
Deduction is being made.
My lord, he is going to retire, my lord, by February, my lord.
Mr.
How
Mahato,
the
what
entire
can be
amount
done?
will be adjusted?
137.
My lord, my petition also, my lord, the annexed.
So from the retirement dues,
Yes,
can be deducted.
That is not the provision.
Yes, there
It's not the provision from the
Why?
retirement. My lord, the scheme is, my lord, only for the, my lord, from this salary,
No, no.
not from the retirement benefit. Indication kindly see. And apart from that, my petition kindly consider to that, man.
Yes. What is your petition?
Next petition, I annexed.
No.
Last occasion, lordship, direction was there.
Yes, what do you want?
My lord, I have challenged the award.
Yes.
I have challenged the award. On the score, my lord, the amount which has been calculated.
দেখি পরের writ petition টা দিন। Yes.
My lord, drawing lordship's attention, page 24.
24, yes.
Got your lordship, this is a summons.
Yes.
My lord, the সদস্য হিসাবে 9 lakh something, my lord, the loan amount taken.
Yes.
How the principal amount here, it has been taken 11 lakh something, and along with the interest. So calculation is also, my lord, the wrong. I made the representation before the concerned authority. My lord, the next page. And next page, my lord, the next page to the assistant registrar and next page to the chairman, manager. That has not been considered at all.
Who is appearing for the bank?
My lord, the bank.
I am for the petitioner bank.
Yes.
So, my lord, my responsibility, my client is interested to make payment, only considering that aspect. And
What according to you is due? How much amount according to you is due?
my lord, that is principal amount. It would be, my lord, 9 lakhs, which has been admitted. How
9
the
lakhs.
principal?
And you are not liable to pay any amount of interest.
Of course,
How
interest.
much? According to you, how much is due?
No, that has been interested. It has been calculated. I have not disputed about that.
So what is the dispute? How much you are disputing?
Dispute relating to the principal amount.
What is according to you the principal
That
amount?
the principal on 9 lakh 84,000 something. That is then in the notice, page 24.
9 lakhs.
9 lakhs.
And
They have stated 11 lakh something.
all right, 2 lakhs is the difference.
Difference.
And with the interest, how much the difference will come?
No, interest I have not calculated. So far, my instruction is that.
9 lakhs is deposit. How soon can you deposit 9 lakhs?
My lord,
9 lakh.
You are not disputing 9 lakhs.
9 lakh within what time?
Yes. Please deposit 9 lakhs.
That is my prayer is also to the bank authority. I am just making.
I'm accepting your. This you are admitting.
Yes.
So deposit, how soon you will pay this?
No, that is
9
my
lakhs?
prayer 20 monthly installment. 20 monthly installment. Or your lordships, my lord, kindly appreciate. Or your lordships kindly appreciate to that when my client going to be retired and the salary already, my lord, deducted, going to be retired after receiving the retirement benefit already.
Affidavit that you will allow this deduction. You will receive after deduction. That will
Yes,
be
I am
deducted
giving
from-
undertaking. I am giving undertaking here and now. By
File
the
an
order.
affidavit to that extent. Your undertaking will not go.
Then your lordship, sir.
Tomorrow the client will come and say, no, I have not instructed.
Then your
File
lordship.
an affidavit.
Then your lordship. They are giving the. I mean, so far my instruction are
So
giving
with regard to that, for the balance that may be considered.
Yes, yes.
So please come out with the figure, principal together with the interest, how much you are admitting.
Yes,
And next week you file an affidavit
yes.
stating that you are willing to pay that.
Yes, yes.
And that will be deducted from the retirement dues.
Of course. Of course.
The learned
Next week.
advocate appearing for the petition
39, my lord.
For registered lordship, 4-5.
Respondent number 9.
Who is for the petitioner?
I am for the petition.
Yes, what do you want?
After last occasion, your lordship directed them.
What is admittedly, my lord,
Your lordship
it
on
was
limitation point. Limitation point.
Limitation point. Yes. Limitation.
Yes, my lord. Yes, my lord. I have submitted the section 52 and he has directed that after 3 years I have come. That is why.
Yes. Now, yes, what is your, yes, Mr. Day, what is the instruction?
sir.
Instruction nahi. My lord, I have no instruction.
Mr. Nayak?
I am for the registered lordship. Now the amount has to be paid. So far as the amount, section 59 will squarely apply in the matter. Therefore, that is to be the responsibility of the person concerned with whom agreement was made, and the concerned party also intimated. So they have to make the payment.
Who has to make the payment?
That
My lord,
is the
respondent number.
respondent. তুমি তো
Respondent
Respondent
is
number.
He is the
My lord, may I make one?
But
On-
district
on
inspector
other,
of school lordship, whole thing is section 59 says the disbursing authority.
That is Mr. Day's liability to deduct that.
Yes, my lord.
Disbursing authority.
Disbursing authority.
কবে টাকা দেবে বলো?
but on last occasion, it was adjourned at my instance. Well, I should be very candid to my lord. So the secondary examination is going on. Despite my best effort, I couldn't get in touch even on over phone with the client. Would your lordship be kind enough to, what is the stand of my client to get the specific instruction, how he is going to pay? If your lordship kindly grant me some more time.
How much time you want?
Retired
1 week time, next week.
On the prayer of
So
the
there
learned
are
advocate
types.
for the respondent numbers 8 and 9.
Only 9, my lord.
9.
9, 8 and
8 and 9. 8 and 9 list.
My lord, 140, my lord, I am appearing for the state.
Yes.
My lord, I am,
Directed to file
my lord, I am
instruction.
my lord, I'll, my lord, apprise your lordship, my lord, but I have, my lord, 2 points of maintainability, my lord. One is, lordship knows, my lord, this is regarding the land manual. My lord, so my lord, this should go to the LRTD, that is my submission. The second leg of submission is that, my lord, this writ petition, my lord, there is, my lord, suppression of facts and, my lord, distorted presentation of facts. My lord, in paragraph 11 of the writ petition, kindly has a,
Challenging.
my lord,
Challenging that, my lord, we have our my lord bid has been accepted. We are the successful bidder. Thereafter, they raise a my lord demand for 1,89,000 and odd. For the period when they did not, till today, they could not hand over the ferry ghat to us. We could not operate it. And in spite of that, they are
yes, my lord, I am, my lord, handing over this instruction, my lord, kindly bears me for 2 minutes. Kindly has a look at this. My lord, this is a part of their bid submission. My lord, the report is there on the top of this document. Kindly sees, my lord, for the last 20 years, my lord, they are in the possession of the ferry ghat, they are running the ferry ghat. And my lord, in paragraph 11, my lord, they claim they want the physical possession in spite of having the physical possession already. So, my lord, this is not a correct state of facts which they have stated.
statement because my lord, from their document, my lord, it will appear that
Kindly,
previously one other person was operating this ghat. My lord, kindly sees
my lord, kindly takes the trouble, my lord, only to the point of maintainability, my lord. I am not on the merit right now. Kindly has a look, my lord, take the trouble to see the page 2 of my compilation, the last paragraph of page 2. Page 3, my lord. I'm sorry, my lord, page 3, the last paragraph of page 3.
Yes.
My lord, I'm placing that Secretary and President of Par Anantapur Ferry Board Poribahon Samiti Limited, namely Soleiman Sheikh and Rahman Ali, duly attended the meeting by putting their signature in the attendance sheet. Following the meeting, an inquiry team visited the Dhulian Deonampur Ferry Ghat, where they were duly accompanied by the Secretary, Par Anantapur Ferry Board Poribahon Samiti Limited, and it was found that they have been running the ferry services. The same is found on various visits. Now, my lord, kindly bear with me for one moment. Then, my lord, kindly has a look, my lord, to the last but 3 paragraphs of the same page. That further, it is found along with the bid document submitted by the Par Anantapur Ferry Board Poribahon Samiti Limited, a certificate issued by concerned MLA, wherein it is clearly and explicitly stated that as Par Anantapur Ferry Board Poribahon Samiti Limited is running playing ferry at Dhulian, Deonampur, Fultola,
per Shipur Public Ferry Guard. Copy of the said note is annexed here with marked at R6.
Ferry guard.
Yes, my lord.
My lord, this is not correct because my lord kindly sees our.
This is, my lord, the
their
instruction
document
and, my lord.
33 of the writ petition. They are
Then, Mr. Bhakot, then
No,
it
my lord.
is to be called for first.
Yes, my lord,
Second,
kindly-
the larger issue would be whether the writ petition is maintainable or you have to approach the tribunal.
in their bid document, it is
Yes.
specifically stated that if any,
Sir, Bhakot, first is the maintainability point because
we have approached the DM that is provided in the bid document, my lord.
but it's
That-
Mr. Sir, Bhakot, the settlement is as per the land reforms manual.
Yes.
So whether it does not fall within the Land Reforms and Tenancy Tribunal Act.
No, my lord, kindly,
Right.
my lord, in their document, it is specifically stated jurisdiction has been created that if any dispute is there, they can approach the Honorable High Court or LRTD or both concurrent jurisdiction.
My lord, by consent of parties, jurisdiction is neither conferred nor taken up.
Your lordship has entertained such petition. Number of petition has been entertained by your lordship in this matter. I can cite the decisions also, my lord.
Lordship
you
is
can-
considering this issue.
My lord cannot circumvent.
No, Mr. Bhakot, there are two things I tell you. Because there was a previous decision of the division bench which says that this land reforms manual, this do not form part of either the act or the rules, so a writ petition is maintainable.
It is not it is just guidelines for the management.
Yes. But subsequently, another division bench has held that decision to be par inquirium. And thereafter, it has been held, no, it's the matters connected with land reforms. And it has been held, no, it's before the LRTT, not writ petition. Then another subsequent division bench, it did not notice the second order, but relied on the first order and has held that writ petition is. These are the conflicting views.
Yes.
Now the question is, both the decisions, both are binding. Now, there are some decisions which
Yes.
says, I can choose between when two are there, it can be choose. Now, whether this relates to matters connected with land reforms.
May I, my lord, join, my lord, issue only on one point because, my lord, Section 8 talks about specified act and with an or, it says matters connected to land reform. So, my lord, that or parts comes into play.
Well,
So
as
this
per
is,
the-
this is a matter subject to correction by
Yes,
you.
yes. My lord, before that, my lord, kindly consider their bid document. This is
Right.
the agreement between the bidders and the authority concerned. They have stated, my lord,
Where page?
yes, I am referring the page, that is page 23 of my petition, my lord,
Yes.
and clause 4, that redress of disputes. Dispute whatsoever in nature arising in connection with this ferry shall be adjudicated by the district magistrate Malda or shall be subject to the jurisdiction of the Honorable High Court or subordinate courts in the state of West Bengal. Nothing has been spelled out about the
We
electorate.
have approached the DM.
We have approached.
So where is
We are
the
agree-
decision of the DM?
Nothing has come forth. My lord, we have made representation twice. They did not respond to our, my lord, grievances. They did not, my lord, address our grievance.
Mr. Datto, who is an authority to decide this
My lord, the
DM.
under the land reforms manual?
my lord,
That is the-
under the land reforms manual, my lord, may I kindly
DLR is-
apprise?
Who is the authority to decide
Yes,
dispute?
yes, my lord. The rule number 7, sub rule 7 of, my lord, rule 272. 1 minute. No, this is, my lord, regarding this, the appellate authority. My lord, according to the tender document, my lord, it is the DM. My lord, I can come back
As
with
per
the
the statute, for who is the authority? But if you have mentioned in the bid document some authority, they have approached that authority. And if you say no, that authority do not have jurisdiction, then that decision also goes by that.
Self-contradictory.
Yes. My lord, may I suggest something? My lord, keeps the point of maintainability open and my lord calls for a report because, my lord, I also wanted to submit one thing. My lord, they say in the instruction, my lord, that they have submitted along with the bid document that they have been running because it's a question of fact. If they are already running, my lord, then perhaps, my lord, this issue of, my lord, handing over of possession is only taken to, my lord, get absolved from the, my lord, paying the fees.
My
Let
lord,
them file affidavits.
Yes,
Mr.
that's
Bhakot,
Keeps the, my lord,
because-
maintainability open. I shall argue on this.
Yes,
এটা
but,
একটুখানি
but,
note করে
but
নে
not,
যশ সাহেবের
it is,
query
there
টা।
is no dispute because their document says,
Saying no
no,
dispute.
no,
So there has to be,
no,
have to give them opportunity to file.
yes, what I am referring, it is their document wherein they have stated that the one other.
They are referring to your document.
Yes, you must
document.
No, my lord,
Yes, that is
we
a
are
part of the bid.
my lord, we
You
are
are
the,
referring to his document, he is referring to your
my lord,
document.
we are illiterate person, but they are DM, ADM,
Sir,
they have stated it.
Sir, both running very illiterate persons.
Both men.
Someone is there to guide them.
That's
Always. You know that much better. So you are relying upon his document. He is relying upon your document.
But my lord, kindly consider
So
they
it's
are
a clear case. So nobody is relying upon his document, relying upon the
my lord,
other.
they are also in confusion. For that reason, the superiors have invited the attention of the
Well, let them
subordinate.
file affidavits
Yes,
and
yes.
keeping the maintainability point open, or if you want, because that will get delayed.
Yes.
In the event at the end, it is held, no, it's not maintainable, then you have to go there.
And
Or
government
if
will
you
suffer.
want, I can give you liberty to approach the tribunal. There you can thrash out all points. Otherwise, at the final hearing stage, because I have to keep the point of maintainability open.
My lord, kindly let the file affidavit. It will.
Yes.
The Mr. Dotto Learned advocate
awarding this ferry guard to others, my lord.
You are in possession.
No, I am.
He is in possession, my lord,
They have-
according to my
They
instruction.
have disputed that we are not in possession.
This is their document.
They cannot. Since you are running from.
Then, my lord,
20 years.
this may be noted that we are.
Nobody can disposes you, Mr. Bokos. Yes.
But may I take back that instruction today, or my lord, I'll file it as your lordship pleases. My lord, lordship can keep it with the record, or my lord, I can file it in the form.
Let it be with the record.
Very well, as your
report
lordship.
filed by,
Copy of
you have filed the report of the bunch
My lord,
of
this is my lord in the nature of my lord report, but this is not a. This is perhaps a privileged communication. I would rather give him the opposition.
তাহলে দিয়ে Yes, who is for the petitioner? You are for the?
I mean, Union of India, my lord.
None
Both
appears
parties
for
are-
the.
এটা দিয়ে দেবে না?
Yes, Mr. Shah, same order as in 4.
No, my lord.
No.
It is not this particular case, Lordship, the grant order was issued in terms of 2002 rules in the year 2009. Now, in terms of the grant order, the petitioner was required to obtain statutory clearance so that lease could be granted in his favor. He sat tight over the issue. The valid
Not been granted.
grant order issued enabling him to obtain the statutory clearance so that the lease could be executed. Validity of the grant order was for 6 months. He sat tight over the issue. The validity of the grant order expired. After this so many period in 2022, submitted a representation. Now is this writ petition.
Well, may I file the report?
Kindly see, Miller, the grant order,
এটা একটু দর্শক দিন।
page 10.
Yes.
Kindly see.
গ্রান্ট অর্ডার দেখো না সমাজের।
Portion, in the last portion, you shall be required to deposit before execution of lease as security for your observance of the terms and conditions of the lease. The sum of rupees 25,000 only under the heading K deposits and
Not only
advances.
deputy
that
but by
amount
district
shall be
teacher, ও একটা
deposited
মামলা করেছে, মামলাটা dismissed হয়েছে।
unless the whole or part of it withheld or forfeited by the government for any default on your part, including default in payment of the amount. The draft mining list shall be modeled form in the prescribed list. Now, Millard, your lordship may kindly consider, as your lordship had my learned friend has indicated that this order is also subject to following conditions. In the next page, page 11. Now, this grant of the long-term mining list was issued on 9/6/2009. Then
No, mining lease was not granted. This is the
Grant order.
grant order.
They will
Yes,
grant
that's it. Yes.
subject to.
It's a kind of LOI. In 2016 rules, the LOI, previously it was grant order.
Why this thing, Miller, was not proceeded with?
Yes.
9/6/2009, then on 10/10/2012, Millard, I was informed that in accordance with the order passed by the Honorable High Court at Calcutta, a hearing will be held on such and such, and I was requested to attend the hearing. Then, after that, there is no particular communication as to what I have
Sir
to do.
Bhattacharya,
My lord, it is not that case, my lord.
from 2012 to 2020.
No, let's see, prior to that, 2012, the first writ petition. Prior to that, in 2009, the grant order was issued. He was under obligation to obtain statutory clearance and to deposit the requisite fees within a period of 6 months. Ask my learned senior advisory what steps his client has taken after issuance of the grant order. Nothing has been disclosed.
Take 14 for a second. The representation, what I have indicated, I beg to inform that I have filed a writ petition. I am just keeping the first paragraph. Second,
Hmm.
I therefore request you to kindly in respect of my memo number such and such, letter
What happened to that writ petition?
That has been dismissed. He has not taken any step. It is but by res judicata also.
Milord, kindly see, Milord, this
Where is
is
the other writ petition, Mr. Vadajaji?
Milord,
What was the relief paid in that writ petition?
My lord, I have my lord annexed the Milord.
petition 6556 of W of 2011.
Number
I submit Milord that this has been
last page, Milord.
subsequently
The
withdrawn.
report.
Report, Milord. Last page, Milord. That has been dismissed. He has, my lord, challenged this memo grant order.
2009 dismissed for default.
Step নাই নিজেই তো করতে আমি করবো না আমি দেখিয়ে দিচ্ছি
This for default.
Yes.
dismiss
Have we
He-
indicated that?
my lord, he not only that, my lord, he appeared before the authority and
Mr.
submitted.
Vadajaji, this is delay and latches. Nothing. You have sat tight and you have filed a writ petition, also kept quiet. That was dismissed for default. Fresh writ petition is not maintainable.
I can only submit one thing, Milord, to my before my lord's Milord. I cannot submit
Dismissed for
anything.
default. देखिए तो still proceeding.
Not
Milord, kindly see page 15. I have indicated that what is the position. This is to inform you that kindly withdraw my above mentioned writ application since I do not want to.
I do not want to proceed further before the Honorable High Court.
Page 15.
আরে ওটা তো ইনস্ট্রাকশন রিট পিটিশন এটা রিট পিটিশনের পার্ট
Milord, your lordship, kindly see the annexure B.
So which page, Mr. Vadajaji?
Page 50. I find Milord from the writ petition. I cannot submit anything beyond instruction. Page 15, I find Milord there is a letter issued by Subhashish Mondol addressed to Anandi Banerjee.
Yes.
Not
That
page
is
14
in
years.
2012.
2012.
So how a fresh writ petition is maintainable?
No, this has been withdrawn.
No, not to
Not
proceed,
withdrawn.
non-prosecution. And it has
Without
dismissed
any
for
leave.
default.
The cause of action.
Mr. No, this was a letter in 2012. This was not produced and the matter has been dismissed for default in 2022.
Not only that, your lordship, kindly
Pending.
see, Milord.
This C order 9 rule 9.
Order 9 rule and yes.
Milord, your lordship, kindly see the page 14.
Right hand page. Bottom.
ম্যাম দর্শককে বলছি আমি ওয়ান বাই ওয়ান বলছি দাও না
Yes, I.
Pars fresh suit.
Now, Milord, kindly consider, Milord, that your lordship.
That should not
kindly
be.
consider that
See, you are not vigilant with your rights.
I
You
say,
sat tight over the matter for this and
Milord, may I say one thing? Your lordships have laid down the law that even if a matter is dismissed for default, there is no bar to file a fresh writ application. This
where
is-
is the law? Order 9 rule 13.
No, order 9 rule 13, but even
Oh,
then,
sorry,
Milord,
order 9 rule 9.
I have found out the judgment of the Supreme
And
Court.
more
where the
so,
Supreme Court is saying-
more so when you have said you do not want to proceed. It's not for default. When you do not want to proceed
But that
without
was-
obtaining leave
Milord, kindly
to
consider-
file fresh, it's barred.
I
Order
say, Milord,
23.
I say-
It's barred under
I-
order
I
23
very
also.
respectfully submit
In
that
whatever
Milord,
way you go, Mr.
the
Vadajaji,
principles of res judicata, that is order, that is
it's not res judicata.
that is Milord, issue raised, issue heard, issue decided.
Mr.
That has not attained a
Vadajaji,
final
res
issue.
judicata is one thing. Res judicata, there are various ways restraining a party from agitating the same issue over and again.
Yes.
So now, one of the issue is res judicata. Once the issue has been decided, you cannot again come. Now, also you cannot approach. Now, when you withdraw without any leave, then also,
That is a very-
yeah,
yes.
it's the case. You will not proceed. You have not sought for liberty.
I have not.
It's not the case of withdrawal with liberty to file afresh.
Yes.
So that is also not there. Third is, you did not take steps, it was dismissed for default.
You know, kindly
That
do
also
not-
bars that. You can restore that writ petition You can try your luck
Kindly
there.
do not put me to a remedialess position because it is well
No,
settled that Milord, a person cannot be put
this
to a
is order
remedialess
9 rule
position.
9. Your remedy
No,
is
I say Milord that having regard
you have to restore that writ petition. Fresh writ petition is not maintainable. You are not remediless, Mr. Bhattacharya. Law provides you a remedy. You have to avail that remedy. You cannot say you are remediless. You restore that writ petition, whatever.
Kindly indicate that
Cannot,
I cannot say more.
Milord, prior to this, Milord, your lordship kindly turn to page 14. Page 14.
14 or
and
13.
after all, Mr. Bhattacharya,
Page 14.
even after all, there is a gross
Delay.
delay and latches.
Hopelessly barred by the
Limitation may not be there, but delay and latches is the expression which is being used in writ petition.
No,
May not be limitation because
the
you will
law
see
of
there is.
limitation does not apply stricto sensu in
That is
respect
why
of
I
the
have.
proceedings.
They were saying barred by limitation. I am not using the expression barred. Delay and latches, unexplained delay and latches, because delay for the period from 2012 to 2022 for 10 years unexplained. Then 2022 we have submitted a representation, again went to sleep. Then after the earlier writ petition was dismissed for default, you have also not indicated what happened in to that writ petition here. Have you indicated in the writ petition? No.
I find, Milord, that there are only, Milord, the particular, Milord, pleadings.
You have not indicated.
Milord, just a second, your lordship.
Informed that he does not want to proceed. So if that
From
letter is
paragraph
taken into
7.
consideration, Mr. Bhattacharya, you wanted the matter to set at rest there. Set at rest there. Now you cannot come and re-agitate that matter because this letter is on record.
No, this is on record, Milord. What is here or there?
So you wanted the matter to set at rest in 2012. But somehow you wanted to revive the matter by issuing a representation in 2022. By that you cannot. Asun.
Milord, P13, your lordship kindly see. P13.
What more, Mr. Bondo?
Milord, he himself, Milord, appeared before the authority. He was called for hearing. P13, page 13, P2.
41. That
না, সেটা নয়।
should be put to jail or.
আরে বাবা, তুমি কি বলেছো তোর কতটা বলনি একটু
petition.
One Amir Ali Milord moved a writ petition before this honorable court, and person in compliance of this honorable court's order, Milord, hearing was called for. He appeared before, Milord, that is the letter issued by the authority for hearing. He appeared before the authority, Milord, in the hearings, and he, Milord, submitted a written representation before the P3. Next page, Milord. This is to inform you that I have been instructed to appear on such and such district magistrate at his chamber and such regarding a case number such and such, the matter of Soyad Amir Ali versus State. I have no objection in respect of dispute question raised by the Soyad Amir Ali. I beg to inform that I have also filed a writ petition before WP number before the Honorable High Court challenging the memo dated such and such. This is the memo, my lord, which he has prayed for, which I do not want to proceed. Furthermore, before the Honorable Court, which I have already been issued a necessary direction to my learned, I would like to request such and such a fresh. He himself, my lord, thereafter, my lord, the letter has been issued to his learned advocate not to proceed. Not only that, my lord, in the year 2014, he made a representation before the authority. That appears from my lord, my report.
What representation he has made?
My lord, that is on
Page 6.
2014.
Page 7, my lord, of my report, my lord, page 7.
2014.
That is after this, my lord. We have given opportunity, my lord, on 30th July 14. What he has written, my lord, কিন্তু আমার শারীরিক অসুখের গ্রান্টের সাথে দিতে পারি নাই এই আদেশ বলে
Page 7 of the report.
Report.
Annexure B.
অসুস্থ আমি দিচ্ছি আমি দেবো তোমায় আমি আদেশ বলে এগুলো তো তোমরা বলেনি, এগুলো তো সাপ্রেস করে গেছো। এই আবেদন হইতে আমি অ্যাডভান্স রয়্যালটি কেস জমা দীর্ঘদিন ছিলাম, বর্তমানে আমি ড্রাফট জমা দিতে চাই যাহাতে ড্রাফট ডিউজ ইত্যাদি, বাট হি হ্যাজ ফেলড, but he has not taken any step, my lord, to that.
In 2014 also, you are
given
directed
opportunity
to set tight.
Thereafter, my lord, also, my lord, the authority given an opportunity, my lord.
Next page.
Versus Mondol.
Yes.
letter was
Milord,
given
next
to
page,
you
Milord.
in 2014.
Next page, Milord, your lordship, kindly see next page. The authority also directed him to deposit,
Yes, yes.
but he has failed. Now he has not suppressed, but he has suppressed and not stated anything, Milord, in this writ petition. Opportunity was given to him.
এটা আগের গ্রান্ট অর্ডারটা রেফারেন্স দিচ্ছে
লর্ডশিপ দেখেন
The next matter.
Item number 96.
আমরা যে রিটেন ব্রাঞ্চ কিছু করবে অনেকজন আছে তো বিষয় তো লিগাল ফিলিং অফ মোড ডাউনলোড করে দিয়েছে এটা আগে ডিসকাস করেছিল এখান থেকে তারপর ডিভিশন বেঞ্চ গেছিল রিমান্ডে পাঠিয়েছে আগে সাবমিশন করেছিল রিমান্ডে আমাদের কপি দিয়েছে
Yes, Swiss for the petitioner. None appears for the petitioner.
But on the last occasion, your lordship pleasure was grant me leave to file a supplementary affidavit. My lord, I have also subbed a copy upon my learned friend.
However, today, in the first half,
Well, only for annexing certain relevant documents. My lord, whatever. I should have thought earlier. My lord.
it was supposed
In
to be
fact,
filed.
My lord, what has happened is this, my lord. The petitioner father, may I just briefly recapitulate the facts, my lord. The petitioner father was
You have supplied the copy just.
You can't come back with the instructions.
uh,
Any which way, it was supposed to be filed in 1 week from 18th of November.
tomorrow, my lord, or
Not possible.
Yes, call the next matter.
Item number 98.
Date has been adjourned.
only
It has
one
been
document
adjourned.
I have disclosed, my lord. Nothing more, nothing less.
For one document, you took so much of time. They need some more time to look to that.
That was not.
So many
That-
to disclose that they are entitled to some
It is
time.
also my lord, their record, my lord, which I have disclosed.
Yes, yes.
On the last occasion, what happened here, 10-3, Milord, the appeal before the district magistrate. Prior to appeal, there was a demarcation process done by the BLLRO and found it's an area within the control of the PWD. So, proceeding culminated and the SDO passed the order for police help, challenged before the district magistrate. District magistrate found that since the area of that land is falling as per the record of rights within the domain of Jila Porishad, so no order can be passed under this. So your lordship, by the order dated 18th of September 2025, directed a report to be filed.
18th of September.
No,
or
my lord,
November?
no, not by your lordship. That order was passed by the coordinate bench of your lordship court, my lord. 18th September.
November. September also there is one order.
Yes, yes.
Yes, to submit a report in writing.
Yes, thereafter your lordship's order is 18th of November 2025.
Yes. Now what happened? Report has been filed.
Report is
I'm having your copy.
I have gone through the report.
Yes.
But if your lordship takes up, because now the thing remains whether this is merely because under the record of rights it is showing the name of the Jila Porishad, whether that will do. If your lordship kindly takes up annexure, the first part of the report, clause D, directly.
তন্ময়, এখন দেখে নাও, পরে তোমার কাছ থেকে নিয়ে নেওয়ার কপি।
Yes, printed by the PWD.
But kindly takes up paragraph page 15. একটু better copy টা দিন। 1.5. This is the annexure D, Milord, they are relying upon. Milord, I have a better copy, Milord. Though they have annexed it, I have a better copy. Same thing.
Yes. Yes.
So after this notification, when it is under the control of PWD, whether the point number F will come or survive what the district magistrate is saying, that merely under the record of rights.
Yes, Mr. Bandhavadhyay.
তুমি একটু দেখাচ্ছ, দেখা ওটা তো যে দর্শকের যেটা
আপনাদের রিপোর্ট স্যার
Kindly see page 24 of my report.
24, yes.
Middle with accordingly, my lord. A hearing notice was issued to the concerned parties by memo number such and such by the subdivisional magistrate Kharagpur after hearing all the parties, perusing all the documents, and considering the facts and circumstances of the case, under Section 10(3) of the West Bengal Highways Act, Subdivision Kharagpur ordered the concerned assistant engineer to recover possession and my lord, for possession by way of removal of impeding encroachment. Today, the case is taken up for hearing for final order. It is clear from the case record and other papers that the plot is recorded in the name of Jila Parishad. The classification of the plot is non-Juli, my lord, Palisi, for drainage system. The opponent parties, Tapos Jana, others have been unauthorizedly occupied the non-Juli land of Jila Parishad public land. Subdivision officer Kharagpur ordered to evict the unauthorized under Section 10(3) of the West Bengal Highways Act, but the land is not under the jurisdiction of Highway Authority. It is recorded in the name of Jila Parishad public land. So the order of the SDO Kharagpur passed on such and such is hereby dismissed.
So where is the 10-1 notice?
Well, initially we have taken step under the provision of State Highways Act, my lord, 1964. Thereafter,
In respect of which plot?
The Noyanjili, my lord, the just roadside land of the PWD authority. Noyanjili falls under the Jila Parishad.
It's not the road.
No, just roadside land is Noyanjili. That is the observation of the district magistrate.
Roadside under the control of PWD by virtue of this notification.
That
road is another thing, Noyanjali is other.
See, there is a road, maybe beside the road there is the Noyanjali.
Yeah.
So the road belongs to the PWD, but the Noyanjali is not belonging to the PWD road. That's the difference.
That is from the bar they are saying. There was a demarcation process that was done, undertaken by the
Only
block.
from the demarcation process it was indicated that it falls within the PWD road.
Kindly takes up page 41.
41, yes.
Of the writ petition.
Yes. No, where is the demarcation report?
That demarcation report.
That is page number 41.
41 টা তো ওরা চেয়েছে। That my lord will get from Lord kindly takes up page 62 now.
Mr. Mukherjee,
Page 62.
It also does not say PWD road. It says PWD land.
That's why, my lord, and their notification also suggests that it is under the control of PWD. Now, what they are, my lord, suggesting today,
page 61.
Yes.
Yes.
Page 62, my lord. They are relying now on the record of rights.
Only.
The entire process was done. This was done, my lord, after the demarcation of BLLRO.
My lord, your lordship kindly turn to page 80.
Please give me a minute.
That is Noyanjali.
The encroachment is upon which property?
274. 274.
274.
My lord, page 62, my lord would get the schedule, my lord, at the bottom.
Plot is 274.
274.
Now, how do you establish, Mr. Mukherjee, that 274 is the PWD
Lord,
road?
kindly comes to page 62.
62.
I will read first paragraph and the bottom portion of that, my lord, memorandum, which has been issued by the subdivisional officer. Has your lordship got it, my lord?
Yes.
My lord, it suggests that, however, the opposite party could not produce any document to substantiate their claim on case land, had submission of the assistant engineer PWD Kharagpur subdivisional perused all record. It is clear that the opposite parties had encroached on the departmental land in unauthorized manner. I am skipping the next paragraph. Kindly takes up the land schedule. Plot number 274 in front of plot number 231. So, my lord, this is the entire process has been done after demarcation.
My lord, this is the order passed by the.
This has been done, my lord, entirety. Now, the district magistrate merely What is the basis on which, my lord, they are relying on the record of rights? On the contrary, my lord, kindly takes up, my lord, this, my lord, schedule, that notification I have handed over. That also suggests that in the year 2015, fresh copy. This is a notification, my lord, issued in 2015, wherein entirety of this has been shown within the control of PWD.
Which 2015, what has been shown to be entirely within the control of?
My lord, this notification kindly takes up this first page, column, chart number 2, point number 1.
No. This road is within the highway authority. That's not dispute. Mr. Mukherjee, my question to you is, please show whether plot number 274 is a road or it's a Noyanjuli.
My lord, plot number 274 having a large chunk of area. Lord, your lordship knows if some portion is being utilized by the PWD for the purpose of state highway, and the immediately, my lord, the next pathway, my lord, which is, my lord, facing, my lord, at the, my lord, edges of the PWD road, that is under the control of PWD, and any encroachment. Now, my lord, I'm coming.
Edges is also there.
Yes. Now,
so
today,
whether the Noyanjuli, let us take a hypothetical case, whether the Noyanjuli will also be a government road.
Today, I am asking one question to myself. There are large chunk of land, there may be a strip of land used for the, my lord, purpose of road, and beside that there may be a Noyanjuli within the same plot number. So today, for that reason, my lord, the demarcation program has been done.
That is
why, my lord, they are in a position to show before your lordship to demonstrate, no, the BLLRO,
Where is the
whatever,
demarcation
yes,
report?
that they are not coming.
Well, there, first, my lord, your lordship kindly turn to page 18.
1/8 of
1/8 of my report. Annexure E.
Yes.
Mr. Mukherjee, large, now my lord, submitted before is a large chunk of, but some portion is the PWD.
Mr. Mukherjee has large chunk of properties. That's why.
I'm not disputing about this.
Small
I'm
chunk
not
of property.
disputing.
No small.
Milord,
Small chunk of property.
Annexure E.
Large chunk of property. So
And
C is large chunk of property.
Annexure E, milord.
Yes.
It's a record of right, milord.
Yes.
Dag number 274.
Yes.
Noyanjuli. দাগের মোট পরিমাণ 6.600, দাগের অত্র অংশ, total land is million Noyanjuli. Therefore, there is no question of it is a
275 is
Rasta. But his question is 274, not in question. 276, 408, 40, all are Noyanjuli.
If that be so, my lord, what is the substantiation of, my lord, page 62 of my writ petition?
Then, my lord, it is now it is the report of the accident. Thereafter, it has been found as such. It is, my lord, the set aside by the
only one
district
thing,
judge, district magistrate.
Which? No. That's a different thing altogether. You have carried out a demarcation program.
Yes,
show me the demarcation plan.
Demarcation report.
What does it say? This road is on which plot?
That be so, my lord, I am out of it. The separate proceeding under 62 Act, I have to initiate.
The Mukherjee, you want demolition. You are not concerned with the
Why
proceeding.
I am, my lord,
You are not concerned about the proceeding under one act or the other.
today, my
So
lord,
when
the entire process when has come to an end, and submission even, my lord, made on behalf of the Jila Parishad in this writ petition before the coordinate bank, that Jila Parishad stated, the learned advocate, look, no, we have handed over the land to the management of PWD, since it is facing towards the state highway. Thereafter, my lord, the coordinate bank directed you file a report to that effect. Kindly see how, my lord, clever way that report is being filed by the, my lord, Jila Parishad.
Next date, my lord, I shall file the demarcation report. My lord, your lordship, kindly see and see point number C on my report. Order dated 23rd June 2020 by memo number district magistrate collector Paschim Bengal, wherein he was clearly directed BLLRO Mohanpur to demarcate the government lands on such and such, and 274 Mouja Borai jail number such and such in favor of Paschim Medinipur Jila Parishad, send a detailed report with a sketch map to the AEO and ADM Jila Parishad. Further, AEO and ADM Jila Parishad was directed to deal with the matter such and such. But I have it has not been annexed to this, my lord. If your lordship desired, my lord, I shall file my in the next date. And thereafter, my lord, point number E, however, as per ROR of BLR of Mohanpur roadside drainage now belongs to Jela Parishad, copy and paste page 18, and it appears from the ROR, my lord, all the plot in
Because,
question is the
from the
Noyanjali.
record of rights, it appears that there are two plots.
Three
One is
plots.
No, 274 is the Noyanjuli.
Yes.
275 is the Rasta. Again, 276 is also, all these are Noyanjuli and the Kacha Rasta. Record of rights has some presumptive value, Mr. Mukherjee.
Always, Milord, always, but
Has
Milord,
some
what I
presumptive
see.
value. If you are challenging this
No, I am
recording,
not also. I am not also
so
challenging,
if
Milord.
that is so 274 is a Noyanjuli. Noyanjuli does not form within PWD road.
Today, Milord, what I am on, page 62 order has been passed after considering the BLLRO report.
Mukherjee, that may have been passed, but the higher authority comes to a different view.
No, Milord,
Comes to a different, arrives at a different conclusion, says no. It's a Noyanjili, so it takes into consideration this.
No, not only that, Milord. Here, the plot number 274 is being mentioned in front of plot number 231.
Your plot is 231. Your plot is 231.
Here, Milord, there are different
What is your
plots.
plot?
My plot,
231.
231.
Yes. So in front of that 231 is 274.
274.
And thereafter is the PWD road. Might be. Has to be.
But the report suggests that 274 also belong within the scheduled land.
Scheduled land means what?
Which has been categorized as a PWD land.
PWD, Noyanjali is also a PWD land. Land and road is a different thing altogether.
Yes. Milord, today,
Road, whether the road has been constructed on 274 or 275, that's a different thing altogether.
I am obliged to
So
you.
why are you going to this
I am
disputes with regard to the demarcation?
today, suppose Milord,
You are
Noyanjali,
only concerned.
the Noyanjali
Yes.
is the land of the PWD. Milord, today, if it is land of the PWD facing or edging to the Milord state highway, I suggest Milord, even the 1964 Act can be invoked. Because your lordship, the
Mukherjee,
inclusive definition under the
All
local
right,
bodies.
I will consider that. I will direct filing of affidavits.
Milord,
That
today,
is why-
if the report comes, because
Report will
today
come.
what the state authority wants to give indulge of all these illegal encroacher. So one process is going to end, and now they will have
No,
to
we are not
initiate.
indulging. There is
They
a
will have to
separate
initiate-
proceeding. We may
That
evict
separate
them
proceeding
or
will take
remove.
again the appellate forum. All
But
these
why
things
you
has to
are
be invoked.
why you are insisting the
Because-
court to proceed with the
because in
matter
respect of the
64 Act,
other- in
not by
respect-
62 Act?
Now, assuming I accept your argument and I direct the authorities to proceed under 64 Act. Now, tomorrow some document is produced that no, it's not a PWD road. 1964 Act does not apply. Then the entire proceedings will go.
Today we are
Consider this at one stage.
Today we are
or
in-
I have to decide on which. So that has to be
Today
decided.
we are in
Let
June.
them file
Milord,
this demarcation.
the order passed on June 2025. The order of the district magistrate itself suggests that the Jela Parishad should initiate a proceeding under 62 Act. Till date, Milord, no action is being taken because they want Milord, this person to run pillar to post so that
No,
this
it is not
illegal
correct submission,
encroachment
Milord.
remains safe.
Mr. Mukherjee, if you could have approached that court, I think that proceedings could have been initiated by now. Now you are going 1962, only 2 years. Now, rather than 1962 or 1964, you are fighting for this.
I am fighting because Milord, our proceeding has come to its logical end. At that threshold,
Mr. Mukherjee, you know that
Because
even
today-
if it is goes to the logical end up to the highest court, now it finds there's a jurisdictional area.
today that is jurisdictional error is Mr. Bandopadhyay arguing from the bar. He is not relying upon a inspection report held jointly in presence of the BLLRO. If that inspection report, after perusal of that, the PWD authority passed a demolition order, merely looking at a record of rights, Milord, the district magistrate can, Milord, pass a separate Milord,
Subsequently,
finding.
it appears.
But that is subsequently appears.
No,
That
no.
also from Mr.
The order has
Bandopandhyay's
been
mouth.
passed by the SDO consult for eviction, Milord, page 20. That is subsequently, my lord, it appears from the record.
Consider, a particular plot has not been acquired, but while constructing it encroaches upon a particular plot. So does it automatically belong to the PWD then
That can.
while constructing?
The page
But
18
the
এ তো
land
বলা
is
আছে
not been acquired by.
I could not make myself clear.
I'm sorry, but I
There
could not.
are two adjacent plots. One is a Rayati plot. Now let us suppose there are two Rayati plots. Now one plot has been acquired for the purpose of construction of a road. Now while the process of constructing, it encroaches upon the other plot. Now whether automatically it will vest by mistake while constructing, it has encroached upon an adjacent plot. No proceedings, nothing. Now you come up and say, look, my property has been utilized for the purpose of construction of a road. The authorities say, no, this plot has not been utilized. Now upon demarcation, it is found, yes, it has encroached upon your property, wrongly encroached upon your property. There are twofold remedies. One is the authorities may be directed to acquire, or may be directed to remove that road. Authority says, no, by mistake it was done, we are removing that road from there. So merely because a road has been constructed, it does not vest in that, unless there is a proceedings for acquisition or requisition. So it's a better example. I'm giving you road constructed by the PWD. Let us take the case to that highest, but on a property which does not vest to the PWD, merely by constructing.
But here, Milord, subject to correction,
that's
to private, Milord, when it is, Milord, vis-a-vis government and the, Milord, general citizen of India, Milord, your Lordship's example is absolutely, I bow down. But if it is ultimately a government land,
I gave
utilization of PWD.
Yes. So now it's, Mr. Mukherjee, that's why separate jurisdiction, separate act. What is under the Highways Act is under 62. You are arguing, look, this provision, this is such and such land. 64 Act is not maintainable 62. In one matter, he will be arguing, no, not 62, look 64. That has to be. I'm not blaming you.
No, that's the privilege of advocate.
So the question is, the jurisdiction has to be asserted.
Yes.
When there is a dispute, all is encroachment. Now, all is encroachment. Nobody can say no, that encroachment is not to be removed. But the question is under what proceedings, how it is to be removed. Now, let us assume under a wrong proceeding has been initiated, it proceeds up to the highest authority to a logical conclusion. Then it is detected no, it's there's an error of jurisdiction. On that very ground,
সরানো নিয়ে কথা এইটার জায়গায় ওটা এখন অর্ডার তো দেওয়া হয়েছে রিমুভাল
Then, Milord, your Lordship's record that it's a positive stand of the state that it is under the 62 Act. So tomorrow I make a shuttle from there.
District magistrate my lord ordered in his own my lord page 25 my lord subdivisional office page 25 my lord order
cannot make
on
any
my
separate
report my lord
demarcation and comes to a different final.
Mr. Bandyopadhyay, only one thing, encroachment is admitted.
Yes my lord, yes my lord,
Encroachment is admitted.
yes my lord,
Yes.
my lord, you have kindly turn to page 25.
What
Okay,
steps
order
have you taken to remove that encroachment?
my lord, your lord kindly turn to page 25. Subdivisional officer Kharagpur ordered to evict the unauthorized under section 10(3)
25 of
on
your
my
report.
Yes my lord.
That order set aside.
হ্যাঁ বলছি তো সেটাই তো বলতে চাইছি জজ সাহেবকে
Page 25, yes.
yes sub D Miller D subdivisional officer Kharagpur ordered to evict the unauthorized under section 10(3) of the West Bengal Highways Act 1964.
No,
But
which I could not.
there-
Page 25 of
my report Miller
Last page of the report.
25 is
last
the
page
order of the DM.
DM
Yes.
DM
Yes, which portion?
D Miller D
There is no D.
D আছে তো
Oh, D, yes.
Subdivisional officer Kharagpur ordered to evict the unauthorized under section 10(3) of the West Bengal Highway Act 1960. But the land is under the jurisdiction of the Highway Authority. It is recorded in the name of the Jela Parishad. So the order of the subdivision order set aside. Then he ordered me, Lord, to initiate the proceedings under section 662. His motto is, my lord, for removal of the unauthorized.
Mr.
If it is
Bandyopadhyay,
instead of 64,
this order
it
was
will be
passed, when
62.
this order was passed,
26th of June, 23rd of June, 2020.
what steps have you taken after this?
Yes, my lord, the authority of the council.
All right,
If your lordship directed me, we shall take step, my lord. Your lordship directed me, we shall take step.
there is no stay, there was no stay order.
No, my lord, no.
So if
No,
there was no stay order, what
No,
prevented you? Who prevented you from taking
No,
steps?
my lord, we have not. The matter was pending before your lordship. Therefore, my lord, your lordship, my lord, directed them, we shall take step, my lord, within 2 months. Or any date, your lordship, my lord, within short date, my lord.
File a report stating that this land in question over which
My
this
lord, as your
encroachment
lordship,
is
my lord, as your lordship.
do not fall within the jurisdiction of the PWD road.
My lord.
And it
Pass,
falls,
your lordship, pass the order.
the,
So that I cannot.
the
Grateful, my lord, extremely.